Almighty God, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this House here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen.
Oath or affirmation. Announcements by the Deputy Speaker.
Honorable members, I have received communication from the Honorable Penelope Beckles, MP, Member for Arima, who has requested leave of absence for the period May 29th to June 9th, 2023. The leave which the member seeks is granted.
Bills brought from the Senate. Petitions. Papers.
Minister of Finance.
Thank you, Mr. Deputy Speaker. I have the honor to lay the following papers, papers 1 to 2. The second report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Agricultural Society of Trinidad and Tobago for the years ended December 31st, 2006 and 2007. 3. The consolidated audited financial statements of National Flour Mills Limited for the year ended December 31st, 2021. 4. The consolidated audited financial statements of Point Lisas Industrial Port Development Company Limited for the financial year ended December 31st, 2021. The consolidated audited financial statements of Trinidad and Tobago Creative Industries Company Limited for the year ended September 30th, 2019. 6 to 7, the audited financial statements of National Helicopter Services Limited for the financial years ended September 30th, 2015 and 2016. 8, the audited financial statements of Youth Training and Employment Partnership Program, YTEP Limited, for the financial year ended September 30th, 2021. 9 to 10, the audited financial statements of Invest TT Limited for the financial years ended September 30th, 2020 and 2021. I beg to move that papers 1 to 2 be referred to the Public Accounts Committee and papers 3 to 10 be referred to the Public Accounts Enterprises Committee.
Honorable members, the question is that papers 1 and 2 be referred to the Public Accounts Committee and papers 3 to 10 be referred to the Public Accounts Enterprises Committee. All in favor say aye. Aye. Any against? The ayes have it.
Reports from committees. Prime Minister's questions. Urgent questions.
Puch West.
Thank you, Deputy Speaker. To the Minister of Works and Transport, with regard to a recent report in circulation depicting approximately 750 feet of collapsed road reserve along the seaward side of the Mosquito Creek, which has fallen into the sea due to persistent tidal erosion, will the Minister inform the House what urgent steps, if any, will be taken to address this immediate and dangerous development, which poses a grave threat to motorists and members of the public?
Minister in the Ministry of Works and Transport.
Mr. Deputy Speaker, thank you, and Member for Puch West, thank you for your question in concern. However, the Ministry of Works and Transport currently right now is not aware of any recent reports of the tidal erosion at the Mosquito Creek, whereby the 750 feet of roadway that you're suggesting has collapsed, right? So we are then requesting maybe further information. However, Member, notwithstanding that, the Ministry of Work continues significant work on the coastal, for the coastal protection, especially with the critical work that has been going on. So a lot of critical coastal protection preservation program has been attended to, where we have to date 22 contracts totaling of some figure of $262,740,959.03, right? The program is focused on the vulnerable coastal work, and we're looking at also the tidal issues, erosions, and the urgent suitability to be able to protect our valuable coastline. Furthermore, the Ministry of Works, through the efforts of NIDCO, continues to treat the roadway at the Mosquito Creek with high priority. Currently, there's a proposal put forward by NIDCO, right, in review right now, and we're looking at other viable options and to be able to find the best fit solution for this current issue. Thank you.
Supplemental, member for Oakwood West.
Thank you, Honorable Minister. Allow me to tell you that I am not very comforted that the ministry is not aware of this very important development, so that you can, well, yes, allow me please. Allow me please. Given that the ministry is not aware of this.
Member, 1 second. Members. Honorable members, it's very early in the sitting. Very, very early. Right? I only recognize Oakwood West with a supplemental. Proceed.
Thank you. Given that the ministry is not aware of this very serious issue, can the minister indicate why we should find some comfort that substantial work is being done everywhere else in coastal remediation, etc., as he has indicated, but no work has been done to even recognize and acknowledge that such a crisis exists on the Mosquito Creek?
Minister.
Deputy Speaker, thank you once more. To the honourable member on the other side, it's not that the ministry doesn't recognize. We understand. For us to be able to execute is planning. As an engineer myself, we don't just execute and go on with this. We look at the situation. However, the concern that you're having, and that particular concern with the 750 feet of collapse, with the ministry is kindly requesting further information. If you don't mind, just bring it to the ministry's, to our attention right now, where we could be able to attend to this particular situation. However, that whole coastal side with Mosquito Creek is being attended to, as I indicated before in my contribution. We do have several proposals that we are looking at before we implement.
Supplemental. Oakwood West.
Honourable Minister, following your question, is the minister stating that the Ministry of Works and Transport is unable to do its job, and hence, from the time of filing this question, was not able to find a person to put at Mosquito Creek to verify the issue?
Minister in the Ministry of Works and
Deputy
Transport.
Speaker, allow me to quote the famous Peter Tosh. Fools die for the want of wisdom. With that being said, let me explain. It is not that the ministry is against or not looking at certain areas. We are aware of some of the issues that they're having right now at the Mosquito Creek. We are currently working with NIDCO to formalize a solution. However, this particular problem that you brought forward was now brought to the minister's desk, and we are now going to attend. And if you have any further information, we're just requesting pictures and more information so that we can look into it. That's all I'm saying. It's not that we are not attending to the issue.
Proceed, Clerk.
Johnson notice, questions for oral answer.
Leader of the House.
Thank you. Thank you very much, Mr. Deputy Speaker. There are 3 questions for response, and we'll be answering all 3.
Member for Princestown.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, to the Honourable Minister of Works and Transport, Minister in the Ministry, my apologies. Question number 166.
Minister in the Ministry of Works and Transport.
I'll be answering these questions.
House.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, the estimated completion time for the landslip repairs along the Naparima Mayaro Road in the vicinity of Fairfield Junction, Craignish Village is December 2023. The project details are as follows. General, $1,501,200. Earthworks, $1,904,050. Temporary shoring, $455,000. Roadworks, $772,300. Structural works, including pile-supported RC wall, $3,550,420. Ancillary structural works, $485,100. Drainage works, $525,750. Traffic management works, $16,275. Utility infrastructure, $326,500. Ancillary works, $391,650. Day works, $239,838, with a subtotal of $10,158,083, a 10% contingency of $1,015,808.30. The subtotal is $11,173,890.30. VAT at 12.5%, $1,396,736.41, bringing a total with VAT inclusive of $12,570,627.71, Mr. Deputy Speaker. Thank you. One landslip.
Supplemental, member for Princetown.
Thank you, Mr. Deputy Speaker. To the Honourable Minister, I noticed the Minister of Works in the Ministry is here, but he is not being permitted to answer. But maybe if the Minister took a look at the question, one of the areas was for completion date. Could the Minister provide the completion date, which was not addressed in the question?
Speaker, that was the first thing I said.
Miss.
Next question, member.
Deputy Speaker, question number 167 to the Minister of Works and Transport, please.
Leader of the House.
Thank you again, Mr. Deputy Speaker. Mr. Deputy Speaker, along the Naparima Mayaro Road, contracts for 7 projects have already been awarded, 3 of which have already been completed. Under the Highways Division, with details as follows. Construction of reinforced concrete retaining wall at 25-kilometer Naparima Mayaro Road. The contractor is Ricky Raghunandan Limited. The project cost is $951,311.25, and that is completed. Piling and shoring along the Naparima Mayaro Road, 26.1 kilometers. R. Baldio Singh Services Limited, the cost $538,200. That has been completed. Emergency interim repairs at Naparima Mayaro Road, 30.4 kilometer mark. R. Baldio Singh Services Limited, the cost $252,641.25. That has been completed. The emergency landslip repair at Naparima Mayaro Road within the vicinity of the 30.3 kilometer mark. Namalco Construction Services Limited was the contractor, and the amount of the project is $839,812.50. This work commenced during the first week in May 2023. Emergency slope stabilization and drainage works on the Naparima Mayaro Road. Transit Equipment Rental Limited was the contractor, and the amount of the project is $934,290. Work is scheduled to commence today. Emergency slope stabilization works along the Naparima Mayoral Road at the 38.6 kilometer mark. Calco Limited is the contractor, and the project cost is $931,137.75, and work started on May 22nd of this year. Emergency slope stabilization works along the Naparima Mayoral Road at the 37.8 kilometer mark. Calco is the contractor. The project costs $983,104.87, and work is scheduled to commence today. Thank you, Mr. Deputy.
Brings this down. Next question.
Thank you, Mr. Deputy Speaker. Question number 168 to the Minister of Works and Transport, please.
Leader of the House.
Mr. Deputy Speaker, the landslips located along the St. Julian Road are being and will be addressed by the Ministry of Works and Transport on a phased basis. This calendar year, 2023, funds permitting, the Highways Division plans to undertake slope stabilization works along the St. Julian Road at the 5.2 kilometer and 2.4 kilometer marks. A contract has already been awarded for interim slope stabilization works at the 5.2 kilometer mark via competitive tendering. This project is expected to commence this week. A project for slope stabilization works in the vicinity of the 2.4 kilometer mark is currently in the development stage with an aim for award of contract in fiscal 2023 or 2024, subject to availability of funds. In addition, the Pure unit has 3 other proposed slope stabilization projects along the St. Julian Road that are in the design stage currently. These projects are located at the 2.1 kilometer, 5 kilometer, and 6.5 kilometer marks respectively, and subject to availability of funds, these landslip repair projects are planned for implementation in fiscal 2024. Thank you, Mr. Deputy Speaker.
Request for leave to move the adjournment of the House on definite matters of urgent public importance, statements by ministers, personal explanations, introduction of bills, motions relating to the business or sittings of the House and moved by a minister, public business, government business, bill second reading.
Attorney General.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, I beg to move that a bill entitled An Act to Extend the Terms of Office of Councillors and Aldermen elected in December 2019 to provide for elections in 2023 and to validate the actions of the said councillors and aldermen between the 2nd of December 2022 and the 18th of May 2023 be now read a second time. Mr. Deputy Speaker, I am privileged to stand here today to pilot the Municipal Corporation's Extension of Terms of Office and Validation Bill 2023. The bill is short. It comprises 5 clauses to achieve 3 principal objectives: the extension until the 18th of May 2023 of the terms of office of all councillors and aldermen elected in December 2019 and whose terms expired on the 2nd of December 2022. Secondly, to provide for elections within 3 months of the 18th of May 2023. And thirdly, to validate the functions and actions of those councillors and aldermen between the period 2nd December 2022 and 18th May 2023, and until the commencement of this act for which this is the bill. Mr. Deputy Speaker, 2 significant circumstances have promoted the need for this bill and deserve appropriate reflection. The first is the mandate of this government to empower the people of Trinidad and Tobago to improve on their lives within their communities. The second concerns an interesting part of the history of this country and the considerations which have informed the passage of local government legislation and which serve to lend clarity to the approach which we take today. As to the first, the mandate of this government to empower the people of Trinidad and Tobago was expressed by the Honorable Prime Minister and has been placed on the record of this Parliament by way of amendments introduced in 2022 by this government to bring about a comprehensive reform of the Municipal Corporations Act 1990. That record exists, Mr. Deputy Speaker, in the Prime Minister's statement delivered in this House on the 24th of May 2023. And it suffices for me to say that as part of my pilot today, I entirely adopt and accept that statement as informing our considerations today for the passage of this bill into law. This brings me to the second point, Mr. Deputy Speaker. The second point of importance, the clarity and simplicity of this bill against the historical evolution of our local government legislation. That clarity promotes the passage of this bill today by a simple majority, so that the people's business may proceed, respecting this government's adherence always to democratic principles, consistency in governance, and respect for due process and the rule of law. Local government legislation in Trinidad, Mr. Deputy Speaker, started in 1927, when Trinidad was divided into 8 counties by the Division of Trinidad Act. County councils were established in 1945, with further legislative amendments and enactments in 1967 by Act Number 22 of 1967. In the consultations informing our constitutional ethos and development, and after independence, the topic of local government was addressed by stakeholders before the 1974 Wooden Commission, leading into the drafting of the 1976 Republican Constitution of Trinidad and Tobago. In 1990, Mr. Deputy Speaker, the Municipal Corporation Act came into force. Throughout, the law governing local government has remained under development, driven in particular by this government. As we know, further amendments of a novel nature were introduced by the 2022 Act, the Miscellaneous Provisions Local Government Reform Act, number 11 of 2022. Here we are today, therefore, Mr. Deputy Speaker, with the benefit of the most recent judicial interpretations of the Municipal Corporations Act as amended, pronounced by the Judicial Committee of the Privy Council on the 18th of May, 2023. The Privy Council accepted the Court of Appeal of Trinidad and Tobago's record of the historical evolution of this legislation up to the proclamation of Sections 11.4 and 12.5 of the Municipal Corporations Act. The Privy Council has held, A, that the extension of the term of office of incumbent councillors and aldermen by 1 year constituted no violation of the Constitution of Trinidad and Tobago, but that, B, that extension by amendment could not be interpreted as applying to the incumbent councillors and aldermen whose terms expired in December 2022. Assembled then as we are here today, Mr. Deputy Speaker, our task is simple. We accept the ruling of the Privy Council. We accept now that today we must provide with clarity for the period that has run its course since December 2022 to the 18th of May 2023, the date of the decision of the Privy Council, and up to and including the passage into law of the Act for which this is the bill. Mr. Speaker, in the decision of the Privy Council delivered on the 18th of May 2023, up to that time, the corporations continued to function lawfully and consistent with the provisions of the Municipal Corporations Act, and supported until then by the unanimous decision of the Court of Appeal of Trinidad and Tobago. This reality is put beyond doubt, Mr. Speaker, in the applicability, if it were needed, of the de facto officer doctrine, which is summarized in the authoritative text, Wade and Forsyth, Administrative Law, with your leave, if I may quote from the 9th edition, 2004, pages 285 to 286. And I quote, "The acts of an officer may be held to be valid in law, even though his appointment is invalid, and in truth he has no legal power at all. The logic of annulling all of his acts has to yield to the desirability of upholding them where he has acted in the office under a general supposition of his competence to do so. The incumbents, Mr. Deputy Speaker, continued in office initially on the basis of the view legitimately held by this government that the proclaimed amendments applied to the incumbents, thereby extending their terms of office from 3 to 4 years. This was plainly not an unreasonable view and was one held in good faith, since this was also the view of a unanimous Court of Appeal of Trinidad and Tobago. More directly, Mr. Deputy Speaker, the incumbents acted in their offices after the 10th of February, pursuant to the decision of the Court of Appeal, which held on that date that the 4-year term applied to them. It is plain, therefore, Mr. Deputy Speaker, that the incumbents acted under the general supposition that they were competent to so act, and the logic of annulling all of their acts has to yield to the desirability of upholding them. It follows then that despite the 18th of May 2023 decision of the Judicial Committee, the actions of the incumbents should be considered legitimate in the eyes of the law. The incumbents continued to perform their functions, and the state duly paid their salaries in exchange for their services. In addition, the wider public received the benefit of those services in the public interest. Indeed, there is therefore a case to be made that the government need do nothing to alleviate the uncertainty created by the decision of the Privy Council, that the term of office of the incumbents expired in December 2022. But that is not the way of this government, Mr. Deputy Speaker. There is a good case to be made for legislatively validating those acts. The public interest advantage of doing so removes any uncertainty which has been created with regard to whether the public may rely on those acts and decisions, and avoids the possibility of further or any uncertainty. This takes me, Mr. Speaker, Deputy Speaker, to the clauses of the bill. Clause 1, the short title. This act may be cited as the Municipal Corporations Extension of Terms of Office and Validation Act 2023. Clause 2, interpretation. In this act, councillors and aldermen means the councillors and aldermen elected in December 2019 in accordance with the Municipal Corporations Act. The rationale for that proposed clause, Mr. Deputy Speaker, is that it is intended that this act will apply to all councillors and aldermen who were elected on December 2nd, 2019, in accordance with Section 11 of the Municipal Corporations Act, Chapter 25, Number 4. Clause 3, extension terms of office of councillors and aldermen. The terms of office of the councillors and aldermen, which expired on the 2nd of December 2022, are hereby extended until the 18th of May 2023. The rationale for that proposed clause, Mr. Deputy Speaker, as we have already acknowledged, is the applicability of the de facto officer doctrine, based on public policy and in the public interest, so that this provision is indeed in obedience to that further public interest principle being introduced ex abundante cautela. The advantage of doing so, Mr. Deputy Speaker, is that it removes any uncertainty which has been created with regard to whether the public may rely on those acts and decisions, and avoids the possibility of any further uncertainty. It is in the public interest that the proceedings and actions of the local government councillors and those persons, members of the public who rely on them, should proceed with confidence and certainty. Councillors and aldermen are required, Mr. Deputy Speaker, to represent effectively the interests of the electoral district or municipality for which they are elected, and deal with constituents' inquiries and representations. Councillors continuously work diligently and tirelessly to improve the lives of all persons in their community within the remit of local government. Local government responsibilities, among others, cover public health, municipal police, spatial planning and building inspectorate, disaster management, repairs and maintenance to government schools and specified public buildings, cemeteries and crematoria. Clause 4, Mr. Deputy Speaker, the period for 2023 local government elections. An election referred to in Section 11.1 of the Municipal Corporations Act for the year 2023 shall be held within 3 months of the 18th of May 2023. Mr. Deputy Speaker, the rationale for this proposed clause is incontrovertible. The proclamation issued on the 7th of November 2022, which brought a small number of the provisions of the 2022 Act into force with effect from the 8th of November, substituted 4 years for 3 years as the periods of office of councillors and aldermen. During the currency of the challenges brought in the High Court and the Court of Appeal, Mr. Deputy Speaker, the law remained in force. This government, led by the Honorable Prime Minister, Dr. Keith Rowley, fully endorses that local government elections must now be held so as to ensure the continuity of life of local government corporations for all the persons throughout this country. This clause therefore provides for the period being within 3 months of the 18th of May 2023, and that the writs of election shall be issued in due course by the Elections and Boundaries Commission. This ensures that each member of the public can exercise his or her rights in accordance with the Municipal Corporations Act to participate in the local government election. Mr. Deputy Speaker, Clause 5, validation. That provides that where the councillors and aldermen under Section 3 exercised the functions of councillors and aldermen between 2nd of December 2022 and the 18th of May 2023, and thereafter exercised the functions of councillors and aldermen up until the commencement of this Act, the exercise of those functions and all acts or things done pursuant thereto shall be deemed to have been as valid and effectual as if the Municipal Corporations Act expressly empowered them to exercise those functions. The rationale for this clause, Mr. Deputy Speaker, is to validate the functions and all acts or things done by councillors and aldermen for that period between the 2nd of December 2022 to the 18th of May 2023, and indeed until the commencement of this Act for which this is the bill. Mr. Deputy Speaker, the hard work, diligence, and daily achievements, the progression of projects vis-à-vis the use of plant, machinery, and equipment by the councillors and aldermen are recognized, did not go unnoticed by this government, and are therefore to be validated. Local government bodies have the responsibility for a number of different functions. Examples: the construction and maintenance of local roads and bridges, the construction and maintenance of drains and water courses, local health, general sanitation and rodent control, garbage collection and disposal, development and maintenance of recreation grounds, parks, and public spaces, development and maintenance of cemeteries and crematoria, markets and abattoirs, disaster management, building inspectorate, municipal police, collection and disposal of fecal waste, and distribution of truck-borne water in areas where there is no supply. These are all areas, Mr. Deputy Speaker, which fundamentally affect the livelihood and quality of life of the citizens of this country. There are 14 municipal corporations that form the local administration. These municipal corporations each have an elected council made up of councillors and aldermen. Councillors are directly elected by voters at local government elections, and aldermen are elected by the councillors. Mr. Deputy Speaker, this bill underscores the government's vision for an effective local government system to facilitate the transformation and modernization of local communities. The policy on local government reform approved by the Cabinet in August 2016 spoke to local government as the democratic representative of communities, bringing the communities closer to people than central government, and can be dubbed the voice of communities. The People's National Movement, which forms this government, will ensure that with the devolution from the Ministry of Local Government, municipal corporations report directly to the Ministry of Finance, particularly on fiscal matters, and are adequately equipped and resourced to provide quality service to their communities and to make and improve the quality of life for all citizens. Mr. Deputy Speaker, I thank you for the opportunity to provide clarity and explanation as to the purpose and remit of the 5 clauses within this short bill, which has significant impact as part of the legislative package of amendments encompassing local government reform. I thank you, Mr. Deputy Speaker, for this opportunity to pilot this bill. I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Extend the Terms of Office of Councillors and Aldermen elected in December 2019 to provide for elections in 2023 and to validate the actions of the said councillors and aldermen between 2nd December 2022 and 18th May 2023 be now read a second time. I recognize the member for Siparia.
Thank you very much, Mr. Deputy Speaker, for this opportunity to speak on the bill before this Honourable House. The Honourable Attorney General was very short with what he terms a very simple bill that is before the House. It is a short bill. It may not be necessarily simple because it is short, but it is indeed a very short contribution from the AG in a matter that is so fundamental as having affected the democratic rights of citizens in Trinidad and Tobago. Why are we here today? Why are we coming to Parliament today? Why will we be coming to Parliament next week, the Senate, to debate this bill? It's because of the crisis in which the government, by its actions, has placed this country. That is why we are here today. This is not simply a matter of validating and correcting an error. This is the government acting due to decision of the Privy Council, which found that government is wrong to deny the people of Trinidad the right to vote in the local elections at the stipulated time. The Privy Council has ensured that the rule of law will be followed here, and those rights to elect their representatives will be followed. I want to ask a question. What we are correcting here, the error that is being corrected, whether it is a genuine error or whether it is one that has devious, nefarious thoughts behind it. Was this error that was caused by genuine intentions on the other side? And when you examine it, I will say this, what turned out was not as the Minister of Local Government once told us here, did not have to do with striking out any part of the law, the local government reform statute that was passed last year in 2022, in June 2022, in fact. It has nothing to do with striking out the law. So, we always said, we could not get someone worse than the former Attorney General, but the present Attorney General has proved to be far worse in performance than the then Attorney General. Because you see, the former Attorney General had the honor and privilege in this House to pilot the 2019 version of this bill that created the sections that are being impugned, or the interpretation of those sections. And when that debate took place in this honorable chamber, the then Attorney General, the member for San Fernando West, was at pains to point out how hard they had worked to bring forward that bill and many other pieces of legislation. And so I would like to quote from the Hansard, with your leave, Deputy Speaker. During debate on the second reading of the Miscellaneous Provisions Local Government Reform Bill 2019, and the provision that we are all discussing here, why we are here, is identical in that bill as it was in the 22 bill, which has now become an act. Former AG Arawi said as follows. This is at the Hansard dated 26 June 2019 at page 218. And I quote, with your leave, I myself, well, I can't see how I could be except with myself, so redundant. I myself, together with the hard-working staff of the Ministry of Local Government and Rural Development, the Attorney General's Office, hard work of the member for Port of Spain North, St. Anne's West, the Honorable Senator Franklin Khan, well, now departed, the Honorable Haji Senator Hussein, the Minister of Finance, the Honorable Prime Minister, the Minister of Planning and Development, because we tie in the planning and facilitation development legislation as well, the public procurement legislation, the revenue authority, all of these articulating pieces, the former AG likes those words, articulated pieces, the Minister of Health for his input on the public health ordinances, etc. Before I continue the quotation, I want to point out that these are amongst the most senior ministers in the PNM government of Prime Minister Dr. Keith Rowley. It continues, and what the former AG told us was, I worked together with the staff, Ministry of Local Government, Attorney General's Office, Member of Port of Spain Northwest, North St. Anne's West, Senator Franklin Khan, Honorable Haji Senator Hussain, Minister of Finance, the Prime Minister, the Minister of Planning and Development, the Minister of Health. We all worked on this piece of legislation, which was the local, inter alia, the reform piece of legislation that was put into place. The then AG continued. We spent months of perfection of drafting. We spent hour upon hour of surgery upon the law. We sat at the AG's office and we did hard work on the law, but we were very sensible. And then AG continued. We made sure that there were no poison UNC pills in this bill. I am going to be brutal tonight. No poison UNC pills in this bill, because we do not trust them, and by hook or crook in the process of a joint select committee, we will get the stakeholders in, we will receive their logic. So the AG takes parentage of this particular section, together with the hard work of all these other senior ministers, including the prime ministers. They take parentage, they take ownership of that provision that is now under review and is such a controversial one. So all is well and fine. Fast forward to 2022, the second version, incarnation of that reform piece of law is in place with the identical provision. But before we go there, I want to point something out. We have a piece of legislation that is very difficult after all this hard work to read, and it will turn out to be almost impossible to implement, as we shall see down the road. And we see that they have tried, and some would say deceitfully, but I will not use that language, but they've tried, really by a side wind, to partially proclaim the law to delay local government elections. The Privy Council sent them packing, and so they are forced to call elections. What is instructive again, in that 2019 incarnation of the bill, with this identical provision in the 2010 bill, which has now become an act, same provision. Same provision. I didn't have a crystal ball then, you know. But in that debate in 2019, when I spoke, I raised very serious matters. And I warned the country that the PNM will delay local government elections. Since 2019, in this House, I warned the population because we cannot trust them. We cannot trust them. So as I say, I didn't have that crystal ball, but we know their pattern of behavior, and I'll come back to it. So I want to quote from the Hansard of that date, from my contribution, 26 June 2019, 4 years ago, 26 June 2019, at page 182. I quote from my Hansard contribution on that day, Mr. Deputy Speaker. I would have proposed it today were we going through the finality of the bill. And I made that comment, I paused on the quotation, I made that comment because they had already indicated from the other side they would send the bill to a joint select committee. So I said, I would have proposed it today were we going through the finality of the bill. And that amendment would be to amend what is known as a proclamation clause, which is clause 2 of the bill, to make it clear the proclamation clause of the bill of this act will come into effect on a date to be proclaimed. That's the clause. And I continue from my Hansard contribution, and I would like us to insert there. The drafters will help us. I would like us to insert there, I repeat, and the drafters will help us, except that should not be the proclamation, should not be prior to the expiry date of the present councillors. The proclamation date should not be before the expiry of the present incumbents who were there. So, in that way, we are very clear in law that it will not extend beyond its 3-year term. 2019, June 2019. But that's not all in what is happening here, you know. It's not that I warned all of us in the country about what could follow through based on that amendment to the section 11.4, I believe it is, of the Municipal Corporations Act, where you changed one word from 3 years, change it from 3 to 4, from triennial to whatever the word for 4, quadrennial to quadrennial, change those words. The section 11.4 of the Act. And I'm saying, you said this Act would come into force on a date to be proclaimed. But the way it is worded is ambiguous, it's not clear, and therefore we should put it in clearly, in express words, that it will not apply to the incumbents. So said, the rest is hearing. I said, I think that is something very important. I continue from that Hansard contribution. In any event, were you to do it that way, I mean, it is going to be chaotic. There is no way this very complex activity and administrative things that have to be done can be done in time for that to take place. So that is my first point. The local government reform, Honorable Attorney General mentioned that they predicated upon an Honorable Prime Minister about his local government reform. We'll be hearing those words ad nauseum, and I'll deal with that on another occasion. But respect to this provision, which has been interpreted by the Privy Council not to include incumbents, I make that point first of all, that I warn that we could be doing this. I make the point again, I continue from my Hansard. I think it is very important for us to ensure we do not extend the life inadvertently of these councillors. What time did I start? I want to repeat that. I make the point again. I think it is very important for us to ensure that we do not extend the life inadvertently of these councillors. I make the point that delays have been. There is a poor track record in the PNM holding local government elections. That was the crystal ball I had. Only crystal ball I had, because I'm not a seer woman or seer man. The only crystal ball I had was the track record, the pattern of behavior by the PNM from time way back in the day, and I'll come back to it. And when I made those points, when I raised those concerns way back in 2019, way back, this is what the then Attorney General responded. Who is that? San Fernando West? The member for San Fernando West. The member for San Fernando West. You know, the Prime Minister has this habit of going on stage and talking about, they're only calling the member for San Fernando West, and he calls his name, and he doesn't need to dance like this, you know? And he says, we're always calling to fire him. And what happened? That's exactly what the Prime Minister did. Listen to what everyone was saying. And therefore, when that member for San Fernando West, the honourable member, responded on that very day, I will quote from the Hansard his words. I will answer Sir Paris' question. This nonsensical argument. Sounds familiar? Sounds familiar? This nonsensical argument that we are going to somehow extend the life of people who are serving by 1 year. And the honourable member asked for an amendment to the proclamation clause. He continued, honourable member, as the Prime Minister says often, poppycock. Poppycock. Absolute nonsense. Because, Mr. Deputy Speaker, we have to be reminded that the Honourable Prime Minister said an election will be called when it is due. through you, were those the words of the honorable member for San Fernando West in June 2019. So, no. Absolutely. I'm not done with the story, you know. The honorable member has good reason to smile, because I never thought I would give Jack his jacket to Faris Alvaro, the member for San Fernando West, the deputy speaker. Thought the day would come one day, you know, where I may have to say, okay. So there we are. This is what the honorable member then said in the 2019 debate. So I was spot on. As I said, I didn't have the crystal ball, but I knew that we could not trust the PNM. What I warned about in 2019 happened in 2022 into 23, which is the scenario we are now in. They have, in a sense, really misled the electorate by those words that San Fernando West uttered in this House in June 2019. Boasting, in a sense, they will not extend the term of the current councillors and aldermen, only later on for that exactly to happen. So this is what the honourable member San Fernando West said. And, okay, that's fine. But it's a strange, when you look at the events, the member of San Fernando West then, and I said I didn't think I would give the jacket to the honourable member. What he said then was totally correct. That provision did not seek to extend incumbents. And that is why, when we went to court, we did not seek to strike out the section. Yes, when we went. Yes, we went. Yes, I'm taking that. We went. When we went to court with a team of lawyers led by Anand Ramlogan, we also had in that team our own Senator Jayanti Lakshmi Dayal. And when our team of lawyers went to court on this matter, because I'd said from the day in November 2022, when the then now renamed Minister San Fernando West is now renamed Rural Development and Local Government, he was the person, that member was the person who was pushed forward to change everything. In the same way they're pushing him, he's been pushed now as the poster boy for this local government election. We will deal with that on another day. And I would advise the honourable member, who has such a lovely smile at the moment.
Feeling nice.
I would advise the honourable member, don't get chained up. Don't get chained up. Because when the dust settles, they'll push you over the cliff, so don't get chained up. Yes. So let's back up a bit, you know. We had the law 2019, the bill. It was not passed. It lapsed because the 2020 general elections came upon us and was brought back in the next session, which is this 12th Parliament, this session, yes. And, of course, debated in this House. Now, nowhere in that debate, Mr. Deputy Speaker, nowhere. That's why you cannot trust these people. Not a single line. Our team has looked at the Hansards for that debate. The bill was then piloted by the Honourable Member for Aruka Maloney, the 2022 version. And not a single word in that Hansard talked about extending the life of the government. Not a word. Not a word. Yes? Oh, sure. So what changed? Exit the Honourable Member for San Fernando West as the Attorney General. Enter the legal advisor to the government in the form of the person of the present Attorney General.
Weekly apologies.
And then, so I'm saying San Fernando West had it right.
Oh. Yeah.
That's what I'm saying. Those words that I quoted,
I'm not hearing you right.
I'm telling you,
I'm not hearing you right.
if we had listened to the Privy Council, the Honourable Member was right.
Oh, gosh, I'm not hearing you.
Yes. Because what they said nothing is wrong with the section. Nothing is wrong with the section. It is what happened after. And what happened after, Honorable Deputy Speaker? There was the intervention by the Cabinet. And who was the legal advisor to the Cabinet in November 2022? Who was the legal advisor?
Senior counsel.
That was not the non-senior counsel member for San Fernando West. This legal advisor at that time. The Cabinet could not have taken that decision without legal advice. And what was the advice? The advice is demonstrated in the statement made by the favorite poster boy in November 2022, when the honorable member said, listen, no local government elections. This section 11 as amended in the 2022 Act, this section means that local government elections will be postponed for 1 year.
No, San Fernando West.
No.
They make him.
But remember the case that was brought right up to Privy Council is a case against the Cabinet. The Ravi Balgo bin Maraj as against the Cabinet of Trinidad and Tobago. The Attorney General has joined in the case because that is what the law says, to be joined in matters brought against the state. So therefore it was the Cabinet who took a decision, which is a decision that we have challenged, that was challenged by the team of lawyers and by Mr. Maraj. That decision was to make that section, section 11.4 as amended, to change 3 into 4 and triennial into quadrennial. That was what was being challenged. So nothing was wrong with the law. That's what I'm saying. I'm agreeing for once with San Fernando West. For once. But here it is, we are today. We are here to clean up. I thought at first it's incompetence, but it is not incompetence. That's why I asked the question at the start. Was this a genuine error? Or was it one that is predicated upon malintent? Malefice. Or other purposes, apart from the purpose that they keep pushing. They're saying it is always about local government reform. We wanted that extra year for what? Local government reform. But tell me what you've done. That law was passed June 2022. We are almost into June 2023. 1 year. What has happened with the local government reform, which you said gave you the platform to postpone local government elections, to take away the right of electorate of people, the right of people to select whom they want to represent them? You said it was predicated upon local government reform. So what has happened? It's been 1 year now, Deputy Speaker. It's 1 year, nothing. I've been talking to some of the corporations and they can point to nothing except...
Property tax.
Well, we'll talk about property tax another day. We'll do it another day.
Again, members, right, Standing Order 53 is clear, right? Member for Siparia, and you all must listen in silence. Proceed.
Time goes fast when you're enjoying yourself, Mr. Deputy Speaker. So where was I before I was so interrupted? I was saying...
No, member, again, your statement, we can interpret it different ways. So, no, your statement you just made, it could be interpreted different ways. All right, but again, let's be careful. Yeah. And again, member for Rima, and seeing that I'm on my legs, first of all, you are not in your proper seat. So again, the tolerance of disturbance will be very minimal. Proceed, member for Siparia.
Thank you, sir. If any offense, I withdraw. There was no intention to offend in the statement. I've been speaking with some of the corporations as to what has been done on the local government reform issue. And I'm told that apart from some correspondence in the month of May, where the Honourable Minister has asked for information on certain matters, things to do with flood-prone areas, data on flood-prone areas on vestings, and a few other areas. And apart from 10 persons being hired to assist in gathering the data, they could not point me to any concrete or substantial matter with taking the local government reform forward. So I hope the members on the other side can give us assurance, because this is what you postponed those elections for, saying you want to use the year to go forward for local government reform. So that's one major point there that I'm saying. The problem arose in November 2022 when a wrongful interpretation was given to the section to preclude, or to include, to say the section included the sitting councillors and aldermen. I want to turn to another point, Mr. Deputy Speaker. I was saying that when we debated this in its first incarnation in 2019, we didn't trust the government because the pattern of behavior has been the same. And I'll just spend a very short time on that. We are here to rectify yet another predicament imposed by this inept government. Again, I'm saying at first we thought it was incompetence in drafting, but nothing is wrong in drafting. I want to get that point clearly across. It is not about incompetence in drafting. It is about either incompetence in interpretation of the section and/or the government acting in mala fide, because that is a pattern of behavior. When you're under pressure, don't call elections. Postpone the elections. Postpone it. How did we get here? This is not an isolated error. There's been a pattern of behavior. So let's look at it. In the THA elections in 2021, the PNM lost significant ground in the January 25th, 2021 elections. What happened? There was a tie, 6-6. This PNM government, instead of utilizing the established procedure for resolving tiebreakers, the PNM, in a stunning act of executive overreach, directed the EBC to carve out 15 more seats and kept the incumbents of the 6-6 tie that could have been resolved. Let me see that book, please. Standing orders that could have been resolved by recourse to the standing orders of this House. There is a provision that where there is a tie, you come to the standing orders of the House of Representatives, and that tells us how to break the tie. But the government refused to use that provision. So almost a whole year, the PNM imposed its will on the people of Tobago until the new elections were held December 6th, and of course that resulted in a massive loss for the PNM in the THA election. That's the pattern, to postpone elections. In the Davis South by-election, the same thing happened. The Davis South councillor had passed away tragically, February 14, 2021, so the seat became vacant. And the law again, was clear that you would have to call a by-election. It was not until January 2022, almost 1 year later, that PNM government triggered the by-election for that electoral district. They refused to call that by-election for a year. Sounds familiar? Right now, that's what's going on. Yes. That's what's happening right now. They refused to call it for over a year. And they had to backtrack. Why, Deputy Speaker? Because I wrote a pre-action protocol letter threatening to take the government to court. That's not the only one. The same thing happened for the Belmont by-election. They refused, the councillor had, God rest his soul, had passed away. And again, by-election is due. They refused to call it until, once again, we send them a pre-action protocol letter threatening to take them to court. And then they call the election. The same thing happened with the Barataria by-election. Person had passed. By-elections due. They will not call it until, once again, I send the pre-action protocol letter and the paper. So it's a pattern of behavior on the part of the government. It's also a pattern of behavior on the part of the government. Unless you take them to court, they will never budge. They will never budge. So we had to get this matter right up to the Privy Council. When you look, for example, the failure of the Minister of Finance to file the NIB reports, it was only when legal action was threatened.
Honourable Member, your initial 30 minutes has elapsed. You have an additional 15. You care to avail yourself? Kindly proceed.
Thank you very much, sir. Thank you. And many others, there are many others. The Commissioner of Police ordered that was in this Parliament, we had to go to court, Baldan Mirage, Haridat Mirage, in that matter as well. And there are several others like that, time will not permit me. But the point is to be made that unless you carry them kicking and screaming to the courthouse, they will continue in the illegal ways to abridge people's rights. Look at that case yesterday, that judgment. Isn't that a horrific thing for a child? The Zika judgment that came out yesterday, where the Ministry of Health, the Minister of Health, the cases against the Minister of Health for their failures with respect
Honourable
to a
Member,
child.
again, I would not allow any elaboration on the point, so please, let's don't go down that way. I'll prefer you.
Point
you know,
is,
yeah.
kicking and screaming to the courthouse to enforce rights. That's the point. And there are many examples. So in the few minutes left with me, I would say the bill is innocuous in and of itself, except that we must never ever forget. We must bolt this onto the chest of the Honourable Prime Minister. This delay in allowing the citizenry in Trinidad to have their right to select their representatives. It's not the government, not this Parliament, but for the people. We say vox populi, vox Dei. It is for the people to select their representatives. And they really subverted that process by the illegal postponement of the elections. Now, when we come to the bill, as I say, innocuous in and of itself, remembering, though, as I say, the circumstances which have brought us here and brought this bill before this House. But what troubles me in this is the section, is clause 5. The clause 5 I find very, very troubling. Because clause 5 is now telling us to validate things that have not yet happened. So, the clause that says let's validate up to 18th May. But then the clause 5 is asking us to validate forward. Now, Mr. Deputy Speaker, in my limited knowledge of life, I know the last time that a man was raised from the dead was in the year 2,000 years ago. These councils expired, retired, died, in other words, December 2022. December 22, but clause 5 provides for the validation of actions taken or decisions made by the councils between December 22 and 18 May 22. That's clause 5. It says where the councils and aldermen under section 3 exercise the functions of councils and aldermen between the 2nd December 2022 and 18 May 2023, and thereafter exercise the functions of councils and aldermen up until the commencement of this act, the exercise of those functions and all acts or things done pursuant thereto shall be deemed to have been as valid and effectual as if the Municipal Corporations Act expressly empowered them to exercise those functions. We are being asked to validate things that have not yet happened.
Yes.
We don't know what these things are. How can we come here today? Perhaps the members on the other side will give us an idea of what those things could possibly be, because you wouldn't even know. You don't know, because they have not happened yet. I would really like some kind of clarification how a parliament can be called upon to validate future prospective actions and decisions of a dead council. How can we do that? The wording of clause 5 suggests that the acts and decisions of councils and aldermen will, well, can I get this to separate itself? Yeah, that the acts and decisions of these incumbents will be validated until the commencement of this act. There is no proclamation clause, so that means on assent. What does this mean then? Does this mean that the councillors and aldermen have continued and will continue to occupy offices until the act commences, even though the Privy Council has told us they have expired, they retired? When you look at section 11 of the Municipal Corporations Act, they expired. December 2022, and you're saying they will continue to occupy office. If that is the case, then their acts and decisions will now be validated by this clause 5 going forward. And when would this act come into be? When will be the commencement of this act? When? The day after it is passed? Today? No, we know that can't happen. The day after it is passed in the Senate? When? And we don't trust you, because in the same way you said that your amendments to Section 11 of the MCA did not apply to the incomers, I don't trust you that you will get this up to the President ASAP. So what is it that we are doing to validate things we don't even know what they may be? Some clarity is needed, as the rest of the bill suggests that the cutoff time is the 18 May 2023. That is the date of Privy Council judgment. In fact, this clause 5 is in some senses in conflict with what is happening in the rest of the Act, because the Act acknowledges that the cutoff date is 18 May 2023. It doesn't say, well, you could go 2 months down the road or 5 months and we'll validate everything. I don't know what you're going to do, but hey, take this validation. Take it. Do what you want now.
Spending money.
Is this then is for them to use in their corporations, to pull out money, to spend money, pave roads? That's already happening. Pave roads all over, pave roads that they want, hire people. What is it for? What future things are you validating? Why are we doing this? It's in conflict. And you know, when you even read the explanatory note, nowhere in this explanatory note does it say that, you know. The bill seeks to provide that those councillors and aldermen whose terms of office expired in December 22 shall be deemed to have continued in office until 18 May 2023. Yeah, so fine. Deemed to 18th. It also seeks to validate their actions taken or decisions made between 2nd December 22 and 18 May 23. Lastly, the bill seeks to provide that local government elections for the year 2023 shall be held no later than August 2023. Where is this thing now about validating going forward? Not in the explanatory note. Again, you see how devious they are. Not in the explanatory, but come inside the Act and open up the fine print and see clause 5. Clause 5, validate after the 18th. Validate after the 18th until some uncertain date. I feel very, very uncomfortable. I feel very uncomfortable with supporting a provision like that. The clause, as I say, as currently worded, conflicts with the remainder of the bill. For example, the bill extends the time of the term of office until May 18th. And then this clause 5 talks about validating actions and decisions beyond the 18th of May. So that's why I'm calling it, in a sense, the Lazarus Bill, that you seek to resurrect a council, councillors and aldermen who are already retired. They're already, in effect, dead. They do not have the legal capacity to take decisions and actions based on the Privy Council ruling. So we'll ask for some clarification about that. And the provisions, the provisions with respect to validation, question, not about local government reform. I don't want to hear about local government reform here. That's not the bill we are debating here today. The Prime Minister made the same mistake last day he came here to talk. On the borough, what is it? The borough status. Coming to tell us about all the local government reform and how much it's going to help. And not one of those things applied to any borough. No change whatsoever in the status. So the bill we are debating here is a validation bill. You have called it a validation bill. You know, we may have done it differently. I could suggest we should have done what Mr. Manning did when he postponed the elections how many times? About 5 or 6 times here. For almost a whole decade there were no...
4 years.
Not 4 years, but almost a decade.
7 years.
Almost for a decade there were no local government elections by Mr. Manning. But his amendments were never challenged because they were express words in the provision, in Section 11 of the Act, which said, you know, say for the elections for the year 2002, 2006, 2007, all these years, say for those, they shall be held within 1 year. And Mr. Manning's cabinet and government came to the Parliament with those when the term of office of the sitting councils on one occasion had already expired, which is the situation here today. I think Sanfona East should be very proud of that, that they got it right, and that wasn't challenged. We could have easily done that here, extending the term of office towards a certain date, and for the calling of the elections, we didn't do that. So I would respectfully suggest, and we will file an amendment, that the clause 5 should be deleted. And by extending the terms of office in the other sections up to a certain date, fix a date. Fix a date. You extend them to a certain date, not an uncertain date. Extend them to a certain date. And that is what we would want to do. So with those words, again, I think it is really a sorry pass our nation has come to when a government seems hell-bent on not listening to the people, not paying attention to what people want, and therefore, in this local government election, whenever it's called, we are ready. And I say to people, do not vote, just go and vote. And when you go to vote, you go vote UNC. I thank you very much.
Thank you, Mr. Deputy Speaker. Just to confirm, sir, is it 45 minutes? 45 minutes of speaking time?
To initially, and your additional 15.
Thank you very much. Mr. Deputy Speaker, I rise to contribute to this validation bill. It was interesting to listen to the member for Siparia speak a moment ago. In winding up, the honourable member said, I don't want to hear about local government reform, after spending all her time on the bill to deal with local government reform in 2019, in 2020, in 2022. Nearly 3/4 of the honourable member's contribution was on local government reform. But in typical fashion, for advice coming from the UNC, it is do as I say and not as I do. So, Mr. Deputy Speaker, permit me to jump into the crux of what is before us. Let's go in reverse order. The honourable member for Siparia has made a recommendation to this House that there should be a principal amendment to the Municipal Corporations Act, specifically by amending the Act and extending the life of the council, and then to go on to provide for elections. That's what the honourable member said. The honourable member premised that upon the basis of amendments done in a previous government in the period 2002 to 2007. Mr. Deputy Speaker, I want to remind that we are here debating a validation act. That's what we're doing today. It is a validation act. And that is very separate and distinct from the Municipal Corporations Act. There will be amendments to the Municipal Corporations Act if required. In fact, submissions are being considered by the Honourable Attorney General. But the point is, the most important thing for us to do, priority number one, is to validate the acts of persons who sat as councillors and as aldermen in the period 2019 to May 2023. Why do we need to do that? May 2023. Mr. Deputy Speaker, the purpose is to validate the acts of persons who sat as councillors and aldermen in the period from 2019, when they were elected in December 2019. They ran a term which expired when the Privy Council's decision came, and the continuing effect of the law having to be, validation law having to be passed, is that we need to contemplate the ending of the cycle for debate and the assent to the law. So let's deal with the bill before us. And I know that the Honourable Attorney General has some amendments to circulate in respect of the bill. Very minor, to take care of a definitions aspect. because, Mr. Deputy Speaker, sitting amongst us in this House are members that sat in local government, and there were several by-elections held. The member for Moruga Tableland, the member for Point Fortin, the member for Toco Sangre Grande, the member for Diego Martin Central. They all sat in the municipal corporations in 2019, and when they were elected into the House in 2020, they came in, and therefore we had to have by-elections there. And then, of course, there was the DB South, where there was a death, and we had to have a by-election. So it's a small amendment to the definition of councillors and aldermen. In treating with this particular law, we are here because of a decision of the Privy Council. The decision of the Privy Council has produced what is now to be interpretation of the law principle. The fact is that in getting to the decision of the Privy Council, the High Court and a unanimous bench in the Court of Appeal and 2 dissenting judges in the Privy Council all held the view shared by the Honourable Attorney General, our Attorney General, the Honourable Senator Reginald Armour, SC, that the proclamation of an amendment to Section 11 and Section 12 of the Municipal Corporations Act would apply such that people who were elected for 3 years as councillors under Section 11(1) of the Municipal Corporations Act, and persons who were appointed as aldermen under Section 12 of the Municipal Corporations Act, by turning on the amendment to move from 3 years to 4 years, High Court judge, 3 Court of Appeal judges, and 2 Privy Councillors all held that that was sufficient to cause a move from 3 years to 4 years. Mr. Deputy Speaker, it is true that an amendment to the Municipal Corporations Act could have been entertained. This is not the first time that the life of councils of municipal corporations are being extended. In fact, Mr. Deputy Speaker, historically speaking, the first local government election was in 1968. The second local government election was in 1971. The first postponement of a local government election was actually in 1974, when it was shifted to 1977. We held elections in local government in 1980 and 1983. We then had another postponement, the second postponement of local government elections, 1986. It was postponed to 1987. In 1990, we had another postponement of local government elections, this time to 1992. In 1995, there was another postponement of local government elections to 1996. In 2002, there was a postponement to 2003. In 2003, there was a postponement to 2006. And in 2006, there was a postponement to 2010. There were all reasons for these postponements of election, be it what was then described as the Black Power Revolution in the 1970s, be it the 1990 coup attempt, which caused an extension of time, be it the fact that local government reform was being sought after legislatively in the period 2003 to 2007 to 2010, those were reasons for local government elections postponement. What is very warming is that the Privy Council decision sets forward absolutely clearly that there is no breach of any constitutional right by the extension of time for the or postponement of elections. Why? Because the Privy Council, as did our Court of Appeal, held very plainly that there is no reflection of local government in the Constitution of the Republic of Trinidad and Tobago. However, Mr. Deputy Speaker, there is a qualification to that statement, because the Privy Council stopped short of going any deeper into the constitutional reliefs. They simply said there was no need to go deeper. They agreed with the Court of Appeal that the Constitution was not infringed by the move from 3 years to 4 years, which had the effect of extending by 1 year. If we are to take the Honourable Member for Siparia's advice and amend the Municipal Corporations Act and simply extend the life of councillors and aldermen, we're going to end up in the face of the dicta of the Privy Council. And the Privy Council was very careful in its language to say that that might be viewed as an interference in the right of the majority of people in this country to vote, as it relates to their councillors. And therefore, prudence dictates that the Validation Act treats with the extension of the life of council and the validation of their acts, and that instead, as I have your attention, Mr. Deputy Speaker, and that instead we do not amend the Municipal Corporations Act to extend the life of the council. This is so, Mr. Deputy Speaker, because it's not the first time that interpretation has brought us a different result. I'll use, by way of an example as to why this is appropriate, the case of Ravi Balgobin Maharaj versus the Attorney General, which challenged the acting appointment of a Commissioner of Police. What came up in that interpretation action was a change of the law. Our courts held that the tool which we used by a legal notice number 103 to appoint acting commissioners of police without reference to the Police Service Commission, that was wrong. The Honourable Member for Siparia acted as Prime Minister for 5 years and 3 months and used that legal notice number 103 hundreds of times wrongly in retrospect. Can we condemn the Honourable Member for that? No, because it wasn't until the court determined that legal notice number 103 of 1999 was wrong, of 2009, sorry, was wrong, that it became known to us. So now we have a situation where the Privy Council, 3 judges in the Privy Council, disagreeing with 2 judges in the Privy Council, 3 judges in the Court of Appeal, and 1 High Court judge, they have now come to say that if you're going to make amendments and you're going to proclaim them, that you need to make sure that you say that the incumbent people are affected by it. And that is why in 2019, when I piloted the local government bill in referring it to a joint select committee, I was as plain in the language that I used as I did. And that is why the Honourable Member for Siparia had to come back and say that the Honourable Member never thought the day would come when she would agree with me publicly as she did today. Because, Mr. Deputy Speaker, what I'm pointing out to you is that the reason is not dissimilar, Mr. Deputy Speaker, from previous reasons. This is not the first time that we're dealing with an extension of time for the life of a council. This is not the first time that we are here as a parliament treating with a validation act. But Mr. Deputy Speaker, the point is, a validation act is a validation act. It must be a standalone piece of legislation. We did one in respect of the THA, when there was confusion by the Office of the President then over the calling of a THA election. And we had to come on a Saturday. I sat in the Senate on a Saturday to validate, to bring validation legislation. So, Mr. Deputy Speaker, a validation act is a standalone piece of law. There are amendments to the Municipal Corporations Act, which we piloted in the 2022 Reform Act. The Privy Council has now, by a majority decision, disagreed with all of the judges coming before and 2 of their own to say, listen, if you're going to proclaim a law and apply it to people, make sure it is done by way of express words. That is something that we'll have to treat with. Now, Mr. Deputy Speaker, as to the hysteria of call an election that the Honourable Member referred to, let me point out to you that the Honourable Prime Minister has been pellucidly clear that an election will always be on the cards. In treating with why there is a need for a validation act, as we do now, let me point out it is tied to the need to implement reform. And Mr. Deputy Speaker, I say that because the fact is, the Honourable Member for Siparia when I was authorized by the Cabinet on November 3rd, 2022, to inform of the advice that the government had received that we would be proclaiming the extension from 3 years to 4 years, and that the election would be deferred as a result of that. On November 3rd, I informed that we were dealing with local government reform. The immediate response coming from the member for Siparia was that that was not necessary. Call an election now. That's what the honourable member said. The honourable member said it was inappropriate for me to say that we needed to put the reforms in place before an election was called. But, Mr. Deputy Speaker, I am therefore warned that the Privy Council has agreed with me. Because, Mr. Deputy Speaker, the judgment of the Privy Council says plainly in its majority and minority judgments that it is essential, at paragraph 11 of the Privy Council judgment, this is Ravi Balgobin Maraj, etc., versus the Attorney General. It's the judgment of the Privy Council, 2023, UK PC 17. The Privy Council said that it is imperative that any reforms that are operationalized, i.e. proclaimed, must expressly apply to incumbents. And therefore, Mr. Deputy Speaker, if you took the advice of the member for Siparia in November 2022 to say you could call an election now and put on the reforms after, let me tell you what the devious trick in that statement is, because the honourable member was saying that the member was searching for whether it was an innocent act or a devious act. But let me explain what is devious about saying put on the amendments after an election. The Privy Council has now plainly said, Mr. Deputy Speaker, that if you are turning on an amendment after an election, that it will not apply to incumbent councillors. So if we had an election in December 2022 or up to March 2023 and the reforms were not proclaimed, the very Ravi Balgobin decision in the Privy Council would have said, sorry, your local government reform will come in 4 years later, not in the period March 2023 to March 2027. And you know why that is the case, Mr. Deputy Speaker? It's because the honourable members opposite do not want local government reform. And this government is on record speaking to the fact that local government reform is critically necessary because, Mr. Deputy Speaker, we wish and we desire and we will ensure, as we must, that the reforms and the amendments to the Municipal Corporation Act happen and apply in the term of the council which is to be elected. What do we want? We want a municipal council in the new section 33B of the Municipal Corporations Act. We want an executive council of full-time members in the new section 33C. Mr. Deputy Speaker, we wish to receive...
Standing Order 48.1, relevance.
Overruled.
Mr. Deputy Speaker, we wish to receive a mayor who can control and direct a CEO pursuant to section 33E. We wish to have secretaries of functions that are critically necessary
What
for...
does this have to do with the validation? This is what we 48.
Not giving...
Okay. All right. Okay, member. Member, thank you. Thank you. And just like before, overruled.
I didn't even hear a standing order, Mr. Deputy Speaker. Mr. Deputy Speaker, Mr. Deputy Speaker, I'm not giving way, and I'm saying that in making sure that the reasons are set forward as to why we are validating today, it refers back to the reasons for extension in the first place. And Mr. Deputy Speaker, we insist that municipal corporations shall have the power to hire under the amendments to section 34 of the Municipal Corporations Act. And Mr. Deputy Speaker, we insist that corporations receive millions of dollars extra in revenue by taking residential property tax pursuant to amendments to the Property Tax Act by a new Section 9A of the Property Tax Act, where all revenue for residential property taxes go to the municipal corporations, and that it is spent by amendments to Section 10 of the Property Tax Act.
Standing order.
Mr. Deputy Speaker.
On a standing order. Standing order 48-1. What does the property tax have to do with this validation bill?
Overruled, member.
Speaker, the Validation Act, therefore, standing as it must, where every other validation act in the history of this Parliament was a standalone validation act. That's the first point. You'd think the Honourable Member for Siparia would know that. Secondly, Mr. Deputy Speaker, the fact is that the Municipal Corporations Act has been partially proclaimed. We now have guidance which tells us that all things are equal and that we are therefore clear that any amendments to law which have to be put on must be specified to be for incumbents. So that is a signal to the need for the government's completion of its decision-making on the need for further amendments to the Municipal Corporations Act. But, Mr. Deputy Speaker, when you get to the further issues raised by the member for Siparia, the member for Siparia, in looking at Clause 5 in particular, said that this was a dead man clause, a Lazarus clause. The honourable member said that Clause 5 was asking for something which had never been done before. And Mr. Deputy Speaker, if you look at Clause 5, which is the validation clause, it says, where the councillors and aldermen under Section 3 exercise functions of councillors and aldermen between 2nd December 2022 and 18th May 2023, and thereafter exercise the functions of councillors and aldermen up until the commencement of this Act. The exercise of those functions and all acts and things done pursuant thereto shall be deemed to have been as valid and effectual as if the Municipal Corporations Act have expressly empowered them to exercise those functions. So let's deal with what needs to be validated. Mr. Deputy Speaker, it is the honourable member for Siparia who would be most aware of the case of Chandray Sharma. That was a case which had judicial pronouncement on the right of a member to receive salary and emoluments. If we accept the member for Siparia's view today, is it that aldermen and councillors are not to have lawfully received their remuneration and perquisites, Mr. Deputy Speaker? Is that what the member for Siparia wishes? Surely not. Mr. Deputy Speaker, what are the acts of council? The honourable member sought to pour suspicion and odium, saying that she has never participated in a validation act where things are unknown. Mr. Deputy Speaker, the record of the Parliament will show that validation acts never come with itemized specificity as to what was done. It is always a generalized perspective. But for the record, Mr. Deputy Speaker, permit me to put this on record. The following sections of the Municipal Corporations Act are triggered where only a council can act. So the suspicion that the honourable member for Siparia paused to say, well, we don't know what they're going to do. They're going to build road and they're going to do things and we don't know. Mr. Deputy Speaker, that's just hysteria. Number one, we have turned on the municipal corporations to work under the public procurement law. That's number one, where there are challenge proceedings and transparency. Number two, Mr. Deputy Speaker, resolutions of the council are what are required. And if you look to Section 10(1) of the Municipal Corporations Act, the power of a corporation to be exercised are to be exercised by the council. Secondly, Section 45(1) of the Municipal Corporations Act, it is the council to fix establishment and appoint, discipline, suspend and dismiss employees. That's the act of council. Thirdly, Section 46, it is the council to consult with majority unions. Next, section 57(1). The council is to dispose of personal property used in commission of an offence. That has now been changed by the Public Procurement Act. Next, section 66, 117, 137, 151. It is the council to make rules, standing orders, regulations, bylaws, issue licenses. Section 108. It is the council to submit estimates of expenditure in accordance with the Call Circular 2023. Section 110. It is the council to approve payments into and out of the chairman's or mayor's fund. Section 112(2). It is the council to approve unspent balances. Section 118. It is the council to approve vouchers for payments of money to be disbursed. Section 120. It is the council to approve virements for approval by the minister. Section 130. It is the council to approve taking over of streets. Section 131, Section 132. It is the council to erect fountains, plant and maintain trees, etc. Section 136, 138, 142. Section 162, 163, 172, 175 to 178, 163 to 168, 189 to 191, 200 to 204. So it's right there in the law. Mr. Deputy Speaker, when you look to some of those provisions that I've just read, the virements and positions and the acts of council, to take care of the suspicion that the honourable member put on the record, none of those expenditure items can be done by a lone wolf councillor unless it is a councillor who has been charged with fraud, as the honourable member for Siparia is well accustomed to seeing in UNC corporations, where her own chairman and own councillors are before the courts of Trinidad and Tobago on acts of fraud and still in office. But Mr. Deputy Speaker, why I am raising that is to say those kinds of actions, well known to Siparia, who will not deal with it in the only manner a political leader can, which is to forthwith call for your resignation and fire you, Mr. Deputy Speaker. That cannot happen in this validation.
Mr. Deputy Speaker, I stand on 48.6 based on the remarks that are being made by San Fernando West towards the member of Siparia.
Again, member, I'm understanding where you are going, but I would like you to, come back on stream, right, directly, okay? Right, member?
Being firmly in the stream as I continue to deal with responses now to the contribution from Siparia, who said of the government repeatedly that she was searching for, the honourable member was searching for deviousness in the decision here before us. I say to the honourable member, we share no part in your fantasy, because your reality is to ignore people on charges and call them as heroes in your camp, Mr. Deputy Speaker. So, Mr. Deputy Speaker, when we treat with the matters before us of validation, and when we treat with these things in accordance with the responses on the record, I have read to you all of the sections of the Municipal Corporations Act where validation of the acts of the council are required. Now, there's a material difference between this particular approach today by causing an extension of time to May 18th. The Honourable Prime Minister, the Cabinet, on the advice of the Attorney General, has now effectively triggered Section 11(4)A. What does that mean? By validating the life of councils to May 18th. What we have done is to ensure that an election is now to be held in the period May 18th to August 18th, 2023. 3 months. If this government was interested in doing other things, it could have, as many other parliaments did, it could have put in an advisory committee. Advisory committees were used by amendments to Section 273 of the Parent Act on umpteen occasions. Mr. Deputy Speaker, to cause persons who had expired to continue in advisory capacity, but we didn't do that. What we did, Mr. Deputy Speaker, by extending the validation in Clause 5 to the 18th of May, in particular, we have triggered the fact that an election must be called within 3 months by bringing back to life the expiry date so Section 11.4a can apply. What does that mean? Section 11.4a says an election shall be held within 3 months of the expiry of the term of office of the councillors. These councillors and aldermen weren't there by a flight of fantasy. The High Court, the Honourable Attorney General, the High Court, the Court of Appeal, and 2 Privy Councillors all held the view in very careful, and I agree with them, in very careful positions to say that, Mr. Deputy Speaker, the life of the council could be extended. And Mr. Deputy Speaker, in treating with that, we must now recognize that councillors and aldermen served in lawful office, and therefore we are not going to rely on the implied terms of construction. We want to give all persons cover. And who do we want to give cover to, Mr. Deputy Speaker? Last time I checked,
your initial 30 minutes has expired. You have an additional 15. Care to avail? Proceed.
Thank you, sir. Mr. Deputy Speaker, in ensuring the validation, let me put this on the record. There are 14 corporations, 7 held by the PNM, 7 held by the UNC. Today we come to validate all 139 seats, Mr. Deputy Speaker, now 141. And it was 139 in 2019, it's now 141. And Mr. Deputy Speaker, in validating the acts, we are seeking to ensure that nobody as a councillor or alderman, be they red in complexion politically or yellow in complexion politically, PNM or UNC, that nobody can say that they receive their salaries, their emoluments unlawfully, or that the acts of their councils, particularly in the months of November and December, where emergency works were undertaken, could fall into odium. Mr. Deputy Speaker, this is a benefit that we must take. The Honourable Attorney General put on record the de facto officer doctrine, and that would take care of us. The de facto officer doctrine in our local context is perhaps best set out by our Court of Appeal. And our Court of Appeal made it plainly clear that this was in relation to considering the acts of a judicial officer who had to be reinstated to give a judgment. They traversed the length and breadth of de facto officers. And that basically says you ought to make sure that you uphold the acts and decisions of people who quite simply were complying with what they thought was lawful. In this case, there is not a thought. The High Court said that their occupation of office was lawful. The Court of Appeal said that their occupation of office was lawful. The Privy Council had a split decision in respect of it, but the point is, we have to act on the clarification of the law. Mr. Deputy Speaker, I wouldn't be surprised if the current decision of the Privy Council was held in a different way at a future date. That's not uncommon. We saw it in the case of Matthews, where we were dealing with the death penalty, where there had to be a reversal of decisions. Mr. Deputy Speaker, the law is there to evolve, and an interpretation summons is just that. It interprets the law. So, Mr. Deputy Speaker, there is no suspicion to be found in validation. I've read into the record the sections of the Municipal Corporations Act which apply. We want to give legislative protection and immunity for all 139 councillors. There will be 141 in the next election. We wish to ensure, Mr. Deputy Speaker, that an election is held quickly. We do not want the Interpretation Act to have to apply. In default of an express deadline date, you will be obliged to have an election within a reasonable time. When the member for Siparia stands up and says, we had to take them to court and we had to have an election in 2021 and they delayed, the honorable member just so clean forget about COVID. And what the reason for the delay was, Mr. Deputy Speaker. The reason for the delay was in the COVID pandemic, Mr. Deputy Speaker. So all of this hysteria and hyperbole in relation to election dates, the Honorable Attorney General has piloted a bill today which anchors the fact that we can have a local government election within 90 days from May 18th up to August 18th, 2023. Now, Mr. Deputy Speaker, the one thing that we're sure about, as I've said publicly before, we are very happy with the Honourable Member for Siparia occupying the seat of Leader of the Opposition. It is the good luck which the PNM has to have a leader of that level run a party in consistent losses. We are grateful and we hold the Honourable Member dear, Mr. Deputy Speaker, and pray for the Honourable Member's good health. Mr. Deputy Speaker, the point is, the polls are the polls. What do we wish in this validation bill to do? We wish to cause time for the implementation of reforms to be measured and implemented. One of those factors, Mr. Deputy Speaker, is we want the executive full-time councils. We want it to apply in the 4 years of the next term, not 4 years after, because it doesn't apply to incumbents. How do we treat with that? Not in this Validation Act. That is dealt with by a different mechanism, but I can't get into that because it would be irrelevant at this point. What I'm trying to tell you, Mr. Deputy Speaker, is the Validation Act is the springboard from which...
I rise on Standing Order 48.1. The member himself recognized that speaking on the topics that he is speaking on is irrelevant.
Thank you.
He himself...
All right, thank you. Proceed.
Thank you, Mr. Deputy Speaker. I thank you for your guidance, Mr. Deputy Speaker. I am not concerned by affidavits and pressures elsewhere. So these things go well to encourage you to stand up, Mr. Deputy Speaker. Mr. Deputy Speaker, the key to a validation bill is to protect those who have acted. The springboard that it comprises here today, that it constitutes today, is a springboard into an election. The election has a time frame that is to be applied. The proclamation takes us to the next steps of full-time and, very importantly, to executive councils. Mr. Deputy Speaker, the members of local government in the UNC camp all have plainly said that they don't have the courage to oppose Siparia openly, but they all want local government reform. And I say that without fear of contradiction, as the Minister in charge of Rural Development and Local Government that has met with councillors and aldermen repeatedly, Mr. Deputy Speaker. So, Mr. Deputy Speaker, I support this legislation. I support the need for validation. I separate it from any proposed amendments to the Municipal Corporations Act. I reject, most respectfully, the arguments coming from Siparia, even though the Honourable Member had to say publicly today that she agrees with me on certain things. I wish to say specifically, Mr. Deputy Speaker, I support the Honourable Attorney General in the piloting of this law and the rationale behind this. I think the Honourable Attorney General has made it very clear where we stand, and there is nothing to contradict that advice, and therefore I thank you.
I recognize the member for Barataria Sanwan.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, I rise to contribute to this act to amend the terms of councillors and aldermen elected in December 2019 to provide for elections in 2023 and to validate the actions of the said councillors and aldermen between 2nd December 2022 and 18th May 2023. And in the circumstances and in light of a defeat in the Privy Council, I would have expected San Fernando West, who is the line minister and named as a respondent in that matter, to have changed his tone. his tone was very unbecoming, Mr. Deputy Speaker, in a debate like this in the face of enormous defeat. Because I thought he would have been a bit more timid, because I saw the claimant, Mr. Ravi Balgobin Maharaj, in the public gallery. And Mr. Deputy Speaker, because you have 45 minutes to speak in a debate, it doesn't mean you have to take all of the 45 minutes. Because sometimes you end up talking rubbish. Because I heard the member for...
No, member, again, I'm sure you could use a better word, please.
Thank you very much, Mr. Deputy Speaker. I'm guided. And Mr. Deputy Speaker,
One second. Member for Naparima, right? I think I need to make note of it now. Okay? Please. You continue to make these little outbursts ever so often. I have noted it. Please. So I think I need to get it on the record. Proceed.
Mr. Deputy Speaker, I heard the member for Sanford and the West saying COVID was one of the reasons why this election has to be delayed. Mr. Deputy Speaker, we had a general election during COVID. The member for San Fernando West has a seat in this house because there was a general election during COVID. So it is absolute nonsense, a ridiculous submission to suggest to this honorable parliament that COVID was one of the reasons for the delay of the local government election. Mr. Deputy Speaker, and the reason why we are here today, we are not here today only because of a Privy Council decision. They didn't have a matter before them in a vacuum. It was because of the decision of the Cabinet of Trinidad and Tobago, led by Diego Martin West. And you know, Mr. Deputy Speaker, as Superior said, the member for Superior said, that the PNM has consistently used local government reform to delay local government election. They have done it. And they wanted to do it again last year, Mr. Deputy Speaker, in November, but they were afraid to come to the parliament. So what they did, they legislated by proclamation in this country. They were afraid to face the parliamentarians. When Mr. Manning, he's a brave man, apparently, because he came to the parliament with bills, with express laws to expressly amend the Municipal Corporation Act, saying it applies to incumbent councillors. This government, coward as they are from the electorate, have now come to a point where they are forced to call the election because we had to rely on the courts in this country. Mr. Deputy Speaker, in any democratic society, ordinary citizens who wish to express their right to vote should not have had to go to the UK to let a court in England tell Trinidad and Tobago what to do. But this government is hell-bent on suppressing citizens' right to expression, because the population will judge them for all of the unemployment, for shutting down Petrotrin, for our roads being littered with potholes, for flooding in people's houses over weeks, Mr. Deputy Speaker. The population will judge them. But the member for San Fernando West is talking about it was pellucidly clear that the law is telling us when is election date. No. Diego Martin West must be pellucidly clear today to tell us what date is the election. Call the election.
Okay, thank you. Member, again, member for Port of Spain, member for Port of Spain West, St. Anne's, please, and Separia North, and Separia, please. You all can have the discourse on the outside. Right, again, proceed, member.
Thank you very much, Mr. Deputy Speaker. And Mr. Deputy Speaker, this bill that we're talking about is really giving the Parliament an indication of the time period in which the election will be called. So I urge my colleague from Port of Spain, North, St. Anne's West, to read Clause 4 of the bill. At least read it before you raise on a standing order and have to embarrass yourself. And Mr. Deputy Speaker, we have to go back in the history, and we have to see the reasons in which and how previous governments would have dealt with delaying local government election, and that's the PNM government, because the UNC government in 2010 had to call the election after 7 years when it was postponed by the PNM. And when you look at what happened in 2002, and this is by precedent, this is by way of example, and I'm making a suggestion of what should have been done, was that when you look at Act number 13 of 2003, that was with respect to extending the terms of councillors for the year 2002 for a period further 1 more year. What Mr. Manning did then, when he was Prime Minister, was brought an express piece of legislation saying that the elections due in the year 2002 shall be held within 1 year of the expiry of the terms of the offices of the councillors and aldermen, expressly providing to the Parliament what he intends to do. Express. There was no mention in that Act of 2003 of any validation of any actions by the councillors and aldermen. Their term had already been expired in October 2002 of the previous year. The bill came to the House in 2003, post when the terms would have expired. Same thing like what we're dealing with here. The terms expired in December 2022. We are now here in May 2023. When Mr. Manning was Prime Minister, term expired October 2002, a bill came in 2003, but there were no express words of validating the actions of the councillors and the aldermen. And then I wondered why this clause ended up in this bill. Because you would remember, Mr. Deputy Speaker, last week, in the other place, the Attorney General stood up in the other place when asked a question by Senator Paul Richards. Well, what is the position of these aldermen and councillors? And he said he is relying on the de facto officer doctrine. And he said all of these councillors are operating legally. The aldermen are operating legally. The councils are operating legally. So then what are you validating if you yourself are relying on the de facto officer doctrine? What are you saying? And then you see, the thing is, San Fernando West is raising some fear that councillors may not be able to be paid since December 2022, because we have to validate. No. It is a legal advisor. You were once the legal advisor. It is a new legal advisor of the cabinet who is telling the population that they could be paid because of the de facto officer doctrine. And Siparia was right. Siparia was right when she said that we are going to validate actions prospectively. Now, Mr. Deputy Speaker, this Parliament passed laws already where we validated things retroactively. This government, I think they made an error with the THA election date at some point in time. They're always making these errors. Sloppy governance, incompetent drafting. And we had to come to this Parliament and fix it. There was something with some licensing committee. Again, we had to come to validate in this Parliament. THA validation, they had to validate, Mr. Deputy Speaker. And now they're coming. So all of those bills dealt with what? Validating actions in the past, retroactively, things that were already done. You know what this bill is telling us, Mr. Deputy Speaker? This is logic. Let's divorce ourselves from legal principles for a while, and let's just look at common sense and logic. This bill is telling us, step by step, December 2022, terms expired. Privy Council ruled on 18th of May 2023 that the terms had expired in December. So the bill now comes to extend the term until 18th May 2023. So basically the new expiry date will be when? The 18th of May 2023. New expiry date. But then when you read clause 5 of the bill, it is validating acts of persons whose offices have expired post 18 May 2023. So if I am no longer a councillor, I am no longer an alderman, what am I able to do to validate? I know the law escapes them, Mr. Deputy Speaker, but you cannot tell me common sense also escapes them. It is like saying if this Attorney General, and I hope this doesn't happen, if he's fired in the morning, can he still be able to act as the Attorney General the day after? And the simple answer is no. So what they're saying is that the terms of offices of the councillors and aldermen expired on the 18th of May 2023, but we must be able to validate actions up until this bill comes into force. When is that? We don't even know. You are asking this parliament to legislate uncertainty. We don't do that in any democratic society, Mr. Deputy Speaker. And if for the life of me, the only time I may have to disagree with Sapara is when she commended the member for San Fernando West. But Mr. Deputy Speaker, when you look at the drafting of this bill, it is totally incompetent. It is against basic legal principles. Basic legal principles. And you know this government, they have a tabanka when they lost, that they try to nitpick. Mr. Deputy Speaker, we have a Privy Council ruling. Look, I have the judgment in my hand here. We have a Privy Council ruling. Yet they're telling us what the High Court said. Yet they're telling us what the Court of Appeal said. Yet they're telling us what the minority judges in the Privy Council said. But they're not telling us what the majority said, you know. I know my learned senior, the Attorney General, when I was in law school, first year law school in St. Augustine, he, I believed, would have taught law and legal systems, Senator Armour. And one of the first classes in law and legal system, I'm sure he remembers, or maybe not, is something called the doctrine of stare decisis. That in Trinidad and Tobago, we are governed by this doctrine called stare decisis. It means that if the High Court has a ruling and the Court of Appeal overturns the High Court, we listen to the Court of Appeal. And if the Privy Council overrules the Court of Appeal, we are bound by the decision of the Privy Council. So when you want to add up 3 judges in the Court of Appeal and 2 in the Privy Council to get 5 and 5 more than 3, no, nonsense. Anne and Ramlogan went in England and hang on it, Jack. This is not all fours you're playing where you're counting the amount of judges to see if you have a majority. No, it doesn't work like that. 3 judges.
These members.
3 judges in the Privy Council ruled against the government, and that was the majority decision that we are bound by. And as I said when I started off my contribution, this is one of the reasons why we are here, because of this decision by, and I think we should look at who are the judges who would have decided on this matter. Very, very eminent judges: Lord Reed, Lord Hudge, Lord Briggs, Lord Kitchen, and Lord Richards. And these judges, 3 of them, in their wisdom, would have decided this matter. And in this matter, Mr. Deputy Speaker, I want to put on the record, and I hope that you permit me to put these things on the record, because they are very important for when people after us go back in our history to understand where the PNM took this country. At paragraph 31 of the judgment, it says, "The essential characteristic of a representative democracy, whether at a national or local level, is that the representatives are chosen by popular vote. In a modern democracy such as Trinidad and Tobago, all individuals have the right to participate in the popular vote, subject only to specified conditions and disqualifications." And then I go on to paragraph 34, and this is very important. Paragraph 34, and I quote, it says, "It is inimical to a representative democracy that representatives are chosen by anyone other than the electorate. It is not for the parliament, still less the government, to choose the representatives." Mr. Deputy Speaker, I want to repeat that. It is not for the parliament, still less the government, to choose the representatives. And what this government did in November 2022 was substitute themselves as the electorate to extend these terms of councillors by 1 year, something that was condemned by the Privy Council. And Mr. Deputy Speaker, I want to say that I will speak as long as I want about this judgment, and nobody can hold me in contempt of court. Because after that solid defeat, I saw the Attorney General go on live television telling people, don't talk about his judgment because you could be locked up for contempt of court. The Law Association had to condemn such statements because they are not conducive to a representative democracy like Trinidad and Tobago, Mr. Deputy Speaker. Like Trinidad and Tobago. Mr. Deputy Speaker, what is happening with this country right now is that the PNM has took us to a place where we are all embarrassed to be. We should not have to be here, Mr. Deputy Speaker, validating or extending terms of councillors. An election should have been held in March 2023 already. It should have been held. And now you're asking us, let us validate. What are we validating really? Because we need to understand that. Because whatever laws we pass here can be subject to challenge. They're not insulated from challenges by the court. And are we validating the office of the councillors and aldermen? Or are we validating the decisions of the councils of the corporations? And there's a stark difference between the two. Because if you don't have the capacity to make a decision, then you can't make a decision. And if at that time they did not have the capacity to make the decision, are we validating the decisions that they made? It's a very technical and complex area of the law, Mr. Deputy Speaker. And the Hansard, based on the piloting of this bill, did no justice to it by the Attorney General, because we are still left in a state of confusion with respect to how this bill, or what are the intentions of this bill, because this, in the history of Trinidad and Tobago and the history of local government, is the first time we are doing something like this in terms of validating. In the past, Mr. Manning would have extended the terms of the offices. This is the first time that we are engaged in a validation exercise, Mr. Deputy Speaker. And Mr. Deputy Speaker, you see, when we look again at the clauses of this bill, we are hearing that there's going to be an amendment to be made. That there's an amendment. We are here since 1:30 this afternoon, and you cannot yet circulate the amendment to the opposition. You can't circulate the amendments to the opposition. I mean, Aruka Maloney, you had a chance to pilot this bill and then reach in the Privy Council.
Again, please address the chair. Members, silence.
Thank you very much, Mr. Deputy Speaker. Thank you very much. I'm being disturbed by these members from
No, proceed, member. I overruled. Proceed.
Thank you very much, Mr. Deputy Speaker. And Mr. Deputy Speaker, while I hear two speakers, the Attorney General and also the member for San Fernando West, spoke of that there are no breaches of any constitutional rights. Well, that's obvious because local government is not entrenched, one, in the Constitution. First, I remembered when I spoke on this debate in 2022, I said, why should we have entrenched local government in the Constitution? Because Guyana, we should do it, because Guyana did it, Jamaica has it. Why Trinidad and Tobago cannot give local government the respect that it deserves by giving it constitutional protections? Because we have seen time and time again the whims and fancies of the simple majority of the government can come and run roughshod over the rights of the electorate, Mr. Deputy Speaker. And I know my friend from San Fernando West, I thought he would have been nicer today because he was complimented by Siparia. And the member for Siparia said, that the Attorney General, former Attorney General at that time in 2019, member for San Fernando West, was right when he said that the bill, the law, the local government reform, section 11.4, did not apply to incumbents. He said it in 2019. But then when he came in November 2022, he said he's proclaiming it to apply to the incumbents. What changed your mind, San Fernando West? What changed your mind? Did Mr. Amor wring your hand and said, you have to do this? No, I don't think Mr. Amor is a man of that character. I don't think he is a man of that character at all. But something changed the mind of San Fernando West. And we must ask San Fernando West to tell us what changed his mind. Because he could have saved this country a lot of money, and he could have saved this country a lot of time, because we could have had the election in March 2023. Mr. Deputy Speaker. And Mr. Deputy Speaker, I want to say that San Fernando West and the rest of the government can run as fast as they can, but they cannot hide. Because they now have to go on the political hustings to justify why they wanted to delay local government elections by 1 year. This bill was in your possession since June 2022, 1 year. We did not hear what steps, what actions you are going to take, or you are taking, or you want to take in order for the next 6 months to delay local government election. You can't just come and deny people rights not to vote because you're saying that we have to implement local government election when you're not giving us the specifics and the particulars of what you are trying to implement. And now I want to ask a very important question. When this election is held, within this 3 months from the 18th of May 2023, are we going to elect councillors for 4 years? I hope the Attorney General can answer that question. Are you going to elect councillors for 4 years and appoint aldermen for 4 years? I want to ask the government that, because they cannot implement the local government reform that they're trying to do in the next, 3 months, less than 3 months they have now, Mr. Deputy Speaker. So, Mr. Deputy Speaker, I don't wish to detain this House any longer, Mr. Deputy Speaker. I wish to go outside and meet with the people of Trinidad and Tobago, Mr. Deputy Speaker. Mr. Deputy Speaker, I wish to go and tell the people of Trinidad and Tobago what this PNM government has done to them, Mr. Deputy Speaker. I wish, Mr. Deputy Speaker, to go on the platforms and convince this population that the PNM is no good for them, Mr. Deputy Speaker. They have suffered the people for far too long, Mr. Deputy Speaker. I hope that the election date falls out of the Prime Minister's pocket when he's on the golf course so we can know what is the date of the election, Mr. Deputy Speaker, and I thank you very much.
I recognize the member for Port of Spain South.
Mr. Deputy Speaker, I do take some credit and I apologize for the member for San Juan Barataria. He did not take his tutorial well at law school and some of the fault may lie with me. Mr. Deputy Speaker, all law, Mr. Deputy Speaker, particularly legislation, is subject to different interpretations. And the Municipal Corporations Act is no different. And only simple minds with a lack of honest intent will try to mislead and say otherwise to the public. This country deserves to fully appreciate what actually transpired and why we are here today with the Municipal Corporations Extension of Terms of Office and Validation Bill 2023. This is because the uninformed narrative will want the country to believe that the government of the day did something unconstitutional. That is not so. The uninformed narrative will have the country believe that the government arrived at this stage in a vacuum. Allow me to give some factual context in order to support that main theory about the differing of interpreting one piece of legislation or the law. Mr. Deputy Speaker, by virtue of Section 11(4) and 12(5) of the Municipal Corporations Act, all councillors and aldermen were elected for a term of 3 years, that is until 1st of December 2022. The Local Government Reform Bill was assented to in July 2022 and became Act 11 of 2022. The government took the view that certain sections of the Act enabled an increase or an augmentation in terms of the limit of aldermen and councillors from 3 to 4 years. The challenge to this was on two fronts. The challenge came on these two fronts, Mr. Deputy Speaker. One, that the amendments contravened the entrenched rights to join political parties and express political views under Section 4E of the Constitution, or in the alternative, that the amendments did not apply to incumbent councillors and aldermen. Mr. Deputy Speaker, one piece of legislation, two differing interpretations. At first instance, which is important, and I noticed no one from the other side took time to condescend to what Madam Justice Jacqueline Wilson SC had to say about the application for an injunction. But at first instance, this is what the learned judge said. Having regard to the range of services that the corporations provide to the community, the potential impact of disruption, the scope of the measures that may be taken in the absence of a functioning council, and the fact that the unlawful consequences asserted by Mr. Balgobin turn upon the construction of legislation which the validity of which is not in dispute. The refusal of the injunction was likely to cause the least harm, the least irreparable harm or prejudice. Mr. Deputy Speaker, these are the words of the court. If this injunction is granted, there'll be irreparable harm. And granting the injunction would cause the least remediable harm or prejudice, not granting of the injunction. This matter went to the Court of Appeal, and the Court of Appeal unanimously held as follows: that there was no violation of any constitutional rights, and that the government was correct to interpret the legislation as permitting the extension of the incumbent councillors and aldermen from 3 years to 4 years. Mr. Deputy Speaker, on May the 18th, 2023, the Privy Council arrived at a decision, and for the avoidance of doubt, I want to quote at paragraph 15 of the decision on the constitutional point. Here's what the Privy Council had to say. While it appears from the judgments in the court...
Member, fix your mic properly. Yeah. Yes.
Is that okay, Mr. Deputy Speaker?
Yeah.
While it appears from the judgments in the Court of Appeal that the appellant's submission based on the Constitution was his primary case, it was presented to the board as a secondary argument. The board can deal briefly with the submission based on the Constitution, which, in our view, must fail. Therefore, the Privy Council held unanimously that the actions of the government of Trinidad and Tobago were not unconstitutional. Why haven't they put that on the Hansard, Mr. Deputy Speaker? Because it does not support their narrative. On the second issue of the extension of the term of office for the councillors and aldermen, at paragraph 51, the Privy Council held as follows. And if I read the decision that goes against, I will read the one that goes for. I will put on the Hansard the one that went against. And this is what the Privy Council had to say. For reasons given in this judgment, the board is unable to agree with the Court of Appeal that the amendments to Section 11 and 12 of the MCA in increasing the terms of office from 3 to 4 years apply to the incumbent councillors and aldermen. The board therefore allows the appeal. So here is where the board differed from the Court of Appeal and, to some extent, the learned trial judge. But, Mr. Deputy Speaker, even when the Privy Council made that ruling, It and I will now alert the public that this decision was not unanimous. It was a majority decision, and most importantly, what it meant is that Lord Briggs and Lord Kitchen disagreed with the majority. If you take the extension, by extension, sorry, Mr. Deputy Speaker, the submission from the Honourable Member for Superior, did these two Lord Laws have malintent? Because they agreed with the government's interpretation. Did they have mala fides when they came to that decision? That is why, Mr. Deputy Speaker, I began by saying that, Mr. Deputy Speaker, I'm hearing a lot of noise that is very much disturbing.
Again, I'll protect you. Again, members, honorable members, please, Hoover North and others, please, let's ensure that we listen in silence, please.
Thank you, Mr. Deputy Speaker. So the Privy Council's judgment in this very matter that is being bandied about as some great victory validates and corroborates my point. And I ask the two Lord Laws who agreed with me, on what basis were they acting in this matter for the government of Trinidad and Tobago? They agreed, Mr. Deputy Speaker, because it demonstrates that based on the language of the legislation, it was a reasonable interpretation by the government to say it gives the ability to extend the terms of office of councillors and aldermen from 3 to 4 years. But, Mr. Deputy Speaker, following the doctrine of stare decisis and the hierarchical structure of the courts in Trinidad and Tobago, the Privy Council is the highest court of the land, and therefore the Privy Council, albeit by a majority, has ruled. And may I boldly say that having ruled, this government subscribes and abides by the rule of law. And it brings to mind a fundamental misunderstanding that is why we are here. Because the government, by presenting this bill, is adhering to the decision of the Privy Council and trying, via its legislative agenda, to
Mr.
address...
Deputy Speaker, I rise on Standing Order 55-1B. This matter has already been raised by the mover and the member for San Fernando West.
Overruled.
Thank you, Mr. Deputy Speaker. I will now go on to what I call a treatise on law. Maybe the member for Couva North may take notes. As a matter of looking backwards, Mr. Deputy Speaker, whilst the matter was progressing through the courts, the aldermen and councillors, they were acting. It was prudent to have the aldermen and councillors not cease their endeavors, and it is prudent now not to have their endeavors undone. The honourable member for Superior stated on Hansard that the aldermen and councillors are dead. This is what you do when you're in opposition perennially. Everything is dead. But as a government, we say that we choose life, and we choose the life of the aldermen and councillors, and that is why we bring this piece of legislation out of an abundance of caution to ensure that every act committed between December 2022 and now and continuing is validated. The members on the other side speak, sometimes they speak, Mr. Deputy Speaker, and I wonder if they live in Trinidad and Tobago. If the acts of the aldermen and councillors are dead, what happens to the corporations that are under the UNC control? What are you saying to your burgesses? That everything done during that period is a nullity? What happens, Mr. Deputy Speaker, to the borough of Chaguanas, the region of Couva Tabaquite? What happens to Pinal de Bay? What happens to the region of Princestown? What happens to the region of Superior with its 9 electoral districts? Why don't you come up with a solution for your burgesses, people who claim when they stand up to talk that they were weaned on local government, and all they can say is to call elections for another licking. That's all they're saying. They have missed, however, Mr. Deputy Speaker, the fundamental principle. And what this is that something must be done to validate, and it's imperative that any negative impact of the Privy Council's decision be addressed. And that is why we have brought this legislation here. The Honorable Attorney General must be complimented for the high principles of law that was adopted in this matter and bringing this legislation. And I want to say, Mr. Deputy Speaker, he did not drill down into it, but it stems from the very Privy Council in a decision of Bowe. Bowe and Davis cited at Privy Council Appeal number 44 of 2005. Mr. Deputy Speaker, in that appeal to the Privy Council, there was a shift in the law in the early 2000s where it was said in the OECS, they proceeded on a premise that once you were convicted of murder, the mandatory death penalty applied. But in Rees and the Queen and Spencer and the Queen, that changed. What happened, an issue arose in Bowe as to what happened to persons who were convicted in 1973 when that wasn't the law. And Lord Bingham of Cornhill had to deal with that issue to see how governments, how the legislature, how Parliament must deal with this new thinking on the law. And Mr. Deputy Speaker, at paragraph 42, this is what the Privy Council had to say. These appeals present a difficult and novel problem. If the appellant's case based on principles established and authorities decided before 1973 is judged to be sound, should the appellants be barred from relief because the soundness of the case was not recognized at the time? The problem is acute. Because the board does not judge the appellant's case so based to be sound. The Crown cogently argues that it is unreal to hold that the effect of the law was otherwise than was understood at the time. It is, however, clear that it took some time for the legal effect of entrenched human rights guarantee to be appreciated, not because the meaning of the rights changed, but because the jurisprudence on the human rights and constitutional adjudication was unfamiliar and by some courts resisted. The task of the court today is not to conduct a factual inquiry into the likely outcome had the present challenge been presented on the eve of the 1973 Constitution. That would be an inappropriate exercise for any court to adopt, perhaps turning on personalities and judicial propensities. The task is to ascertain what the law correctly understood was at the relevant time, unaffected by later legal development, since that is plainly the law which should have been declared had the challenge been presented. And then, Mr. Deputy Speaker, what it means is, having pronounced, the government must act, and the government must look back and apply the law as pronounced by the Privy Council on the 18th of May 2023 and as enunciated by Lord Bingham of Cornhill in the case of Bowe and Davis and the Queen. There was no choice but to do what is being done today. And what is important, Mr. Deputy Speaker, is that the government has acted within a fortnight. The government has respect for the intelligence of all the citizens of Trinidad and Tobago. And by this debate, we are engaging the citizenry on matters that concern them not only at present, but presently and in the distant future. Because, Mr. Deputy Speaker, we are here so that any dire consequences that may befall the population if this validity bill is not passed, we are here to avoid that. We want the population to embrace and enjoy the work done by the councillors and aldermen for their benefit and for the benefit of the country. And I ask How come no member on the other side has addressed that issue? Because we are just not here just to pass law. The honorable member for Siparia accuses the government of having malintent. What was the reason for this extension in the first place, Mr. Deputy Speaker? Let us go to that discourse and understand what was the reason. The extra year was to enable the government to roll out the relevant sections of the law, including but not limited to transforming councillors who are executive members into secretaries akin to the THA. That's one. 2, operationalizing the 13 separate divisions inside local government, including planning, engineering, auditing. It was the intention that the next local government election would have been run under the new law in its full form, which involves critical financial benefits to the corporations for their efficient operations. Mr. Deputy Speaker, the extension of time of the term was done, in my respectful view, from the government's perspective, in the best interests of the citizens of Trinidad and Tobago. Mr. Deputy Speaker, the intent was to give life to an August 2016 cabinet-approved draft policy on local government reform. That is 2016, some 6 to 7 years hitherto. The aim was to bring local government closer to the people of Trinidad and Tobago and then call an elections. But all we are hearing from them is call the elections, call the elections. The government was not about delaying elections, because if that is so, there's another course that could have been undertaken. Mr. Deputy Speaker, you know, the honorable members on the other side, they love to quote newspapers' clippings. Why haven't they quoted the Guardian 24th of May 2023 article, quoting esteemed political scientist Professor Hamid Ghani? And here's the headline: government can legislate an extension of local government term. Why haven't they quoted that? Because that's an option. If this government was about just extending time and delaying local government elections, that's an option from an esteemed political scientist. The government is not about that. We are about the people of Trinidad and Tobago, and we are about democracy. So, Mr. Deputy Speaker, I want to bring some context to this bill. The bill has 5 clauses. The Honorable Attorney General has, I think, adequately gone through the 5 clauses. But I want to bring context as it relates to the democracy that is Trinidad and Tobago. Mr. Deputy Speaker, 60 years ago, a true patriot and the original and first member of Parliament for Port of Spain South gave a definition of democracy. I wish at this stage to add respectfully and humbly to that definition. Democracy is a government adopting an interpretation of a piece of legislation. Democracy is a member of the public challenging that interpretation. Democracy is that challenge going all the way to the apex court of the land, and the apex court not agreeing with the government. And democracy is within a fortnight, the government abiding by the rule of law and adhering the rule and the ruling of the Privy Council, even though it was against it. That is the hallmark of democracy, and that is the hallmark of a PNM government. The hallmark of a PNM government. Mr. Deputy Speaker, from 1956 to now, this is all that the PNM government has done. Adhere to the rule of law. And in bringing this piece of legislation, it is my respectful view that the Honorable Attorney General is continuing that legacy. Mr. Deputy Speaker, I thank you.
I recognize the member for Chaguanas West.
Thank you, Mr. Deputy Speaker, for the opportunity to contribute. Mr. Deputy Speaker, having regard to the comprehensive analysis and response of the member for Siparia, leader of the opposition, I don't think there was really any need for anyone else on our side to contribute to this debate. But I have listened to my friend, member for Port of Spain South, and it is in that context, having heard him along with other members as well, my other friend, member for San Fernando West, that I think I should put a few matters on the record, please, Mr. Deputy Speaker. Now, Mr. Deputy Speaker, I listened to my friend, member for Port of Spain South. He started off by, premising his argument on one piece of law, two interpretations. So I think he was trying to make an argument as to why we should somehow find solace in the fact, or whether his side, should be forgiven for the actions which they undertook in postponing the local government elections by virtue of the fact that you have a Privy Council ruling now saying that that was not the proper course to follow. So he said one piece of law, two interpretations. Now, I want to say that that only applies where you have a situation as now, law is open to difficult interpretations only when you can't draft competently and you ignore salient principles of interpretation, such as the principle of legality. And that is what the government fell short in respect of how they brought the November 2022 amendments. So I don't seek any solace in what member for Port of Spain South has said when he said one piece of law, two interpretations. This does not save the government. It does not apply in what we are dealing with here today. So they can't use that as a defense. Now, he went on some elaboration about the principles of granting an injunction and an appeal. And I don't know what was the relevance of that, please, Mr. Deputy Speaker. Talking about the principles that the first instance judge would have taken into account and why it is, irreparable harm would have somehow prevailed and therefore, there was a need for the judge to rule how the judge ruled at first instance. Mr. Deputy Speaker, we have a Privy Council ruling. So I don't see again the benefit of going back to the first instance judge. I don't know in this Privy Council ruling that there were any challenge to the principles that were employed and or utilized by the first instance judge when her ladyship, the first instance judge, refused to grant an injunction. So I think that that really was just making up time, Mr. Deputy Speaker, and it has no relevance. Someone, an unsuspecting member of the public, might think that there is relevance in what he has said, but not when it comes to that part of his contribution. The other point he spoke about is that the members of the opposition are banding about this Privy Council ruling as a big victory. And as though, well, Ravi Balgobin Maraj lost before the Privy Council. I want to say that Mr. Ravi Balgobin Maraj was present from the beginning of the sitting today in this House. I want to say on the record that kudos must be paid to him because having followed through with litigation in what he believed to be a wrong committed upon the citizenry, having obtained a judgment in his favor in the Privy Council, the highest court of the land, he still sees it fit, obviously, to see things through, and that is why he is here today. And it is a big victory, Mr. Deputy Speaker, and the victory is one for the people. It may not be one for the members of the government, but it is certainly a big victory for the people of Trinidad and Tobago. Now, I hear a lot of talk by the Honorable Attorney General, Honorable Member for Port of Spain South, Honorable Member for San Fernando West, and even in a previous statement which was made by the Honorable Prime Minister in this House in relation to this matter, that
the victory that they are claiming, the government that is that the court did not rule that there was a breach of the Constitution. That is a big victory on their part, that there is no ruling in this, that there was a breach of constitutional rights. But this is really to treat with the judgment of the Privy Council in a very superficial, in a very artificial manner. You see, Mr. Deputy Speaker, my learned colleague member for Barataria Sanwan, when he spoke, he pointed to certain paragraphs of the judgment, so I will not reread it. And essentially, it was paragraph 34, paragraphs 36, 39, and where it says that it is inimical to a representative democracy that the representatives are chosen by anyone other than the electorate. And that is why this is a big victory, and why it is we have been saying, and I think it is really artificial if we do not understand that the Privy Council has in effect held that there was some unconstitutional action on the part of the government, is to take too superficial an approach. And I will tell you why, Mr. Deputy Speaker. You see, the law which was brought November 2022 is unconstitutional in the sense that the Parliament attempted to circumvent the constitutional values underpinning a democratic society. That is what was being played at paragraph 34. And that right that underpins a democratic society is where you have a citizen right to elect his representatives. So it is misleading for the government to simply say that the Privy Council didn't find that the government acted unconstitutionally. That is misleading, Mr. Deputy Speaker. What the Privy Council found was that the government did something which the law did not permit. That is what they found. And it has always been the law since Entick and Carrington 1765 that the executive must act within the bounds of the law. That is the essence of the rule of law. That is the essence of the rule of law and the constitution by which we govern ourselves in this country. So a breach, Mr. Deputy Speaker, of the rule of law is a breach of the Constitution. And to come here and pass it off, as though this was merely a claim to interpret the law and the law was found to be wrong, a citizen had to file a claim to stop the government from acting unlawfully. That is what the Privy Council ruled on. If the government wanted, I mean the government now, if they wanted a simple interpretation to the law, then it could have filed what is known in law as an interpretation summons. It did not do so. And therefore, they were prepared to use vague legislation to undermine the rule of legislation, the rule of law, by unlawfully extending the terms of office of representatives. It is just that simple. So don't come here and it is a 3-2, and we had 3 down in the local courts, and those 3 ruled somehow, but the first instance judge in dealing with the injunction held that they would have irremediable or irreparable harm. All of those things, Mr. Deputy Speaker, are totally irrelevant to what we are debating here. Mr. Deputy Speaker, it is also, when we talk about extending the term of representatives, it is undemocratic both because it deprives the right to vote, but it also is undemocratic because, as I said, the executive is taking a step which is not permitted by law. The government, Mr. Deputy Speaker, was infringing the principle of legality, and this is what was clearly held by the Privy Council. The government was infringing the principle of legality and legal certainty, both of which are constitutional imperatives. So you could swing that how you want. You could call whichever law lord you want in whichever case from 2000 or whatever my learned friend from Port of Spain South wanted to cite. The fact of the matter is, when you are infringing the principle of legality and legal certainty, you have bad law. Principle of certainty is very simple, Mr. Deputy Speaker. All it says is that law must be understandable and predictable to the ordinary citizen. When the government tried to use the law for a purpose for which it was not intended, it violated that principle of legality. So, Mr. Deputy Speaker, you cannot undermine constitutional rights with unclear legislation. So no matter how my friends try to slice it and dice it on the other side, regardless of the spin they attempt to put on it, and no matter how much the government tries to convince us, you have violated constitutional principles and democratic principles. That is what this Privy Council has held. So there may be a ruling with respect to a breach of a specific provision of Section 4 rights. We accept that. But if you cannot interpret exactly what they have said with respect to postponing the local government elections and saying that the law was vague, you are really playing smart with foolishness. And you know what is surprising, Mr. Deputy Speaker? My learned colleague, member for Barataria Sawan, spoke about upon obtaining this judgment on the 18th of May, he spoke about the actions or the immediate actions of the Honorable Attorney General, so I will not go into that again. But what you have is that was the 18th of May, and then on the 25th of May, I believe, was the statement made in this Parliament consequent upon this ruling, statement of the Honorable Prime Minister. And he came to lecture us and to lecture the population by extension. And of course, he did it last week, Thursday, on a political platform, that the population should read the judgment. So I want to tell them respectfully, they should read the judgment. And a little word of caution to the Honorable Prime Minister. He should not read the summaries of his failed attorney generals. The present Attorney General, and according to my friend from Barataria Sawan, the previous current Attorney General, both of them have been discredited on account of what the Privy Council has ruled. So that is something that I want to put on the record in response to what my learned friend from Port of Spain South was trying to convince us of. But his analysis of the law, his ratio decidendi, is off target. I think he should have stuck to the obiter dicta and tried to make some sense out of that. Now, so, Mr. Deputy Speaker, another point which was raised by my learned friend for Port of Spain South was he was talking, I have to say Port of Spain South in conjunction with San Fernando West, stare decisis, and the principle of how we have to adopt what the other courts, what the higher courts have said. And that is accepted law. Now, I want to let them know that it is our Constitution and the Supreme Court of Judicature Act which sets up a holistic system of justice, which includes, as most parts, the common law jurisdictions, and we have an appellate system of justice. The decisions, to make it clear, because somebody listening to how we could add 3 to 2 upstairs and how we could go back to the first instance who was dealing with an injunction, that ordinary lay person may get confused. Port of Spain South was confusing them with that analogy. The decisions...
Okay, Honourable Member, I think the maths in the bill now, I think that we have reached a stage which part we could border on tedious repetition, right?
Yes.
I think the maths has been used by every speaker so far, right? So again, I will think from now on in,
yes,
be staying clear of that.
So, Mr. Deputy Speaker, I take your guidance on that. The mathematics of, or the permutations which we have heard from members on the other side, I thought you were about, Mr. Deputy Speaker, no disrespect, I thought you were about to say the maths not mathsing. So I take your guidance, please. So I go quickly along to the appellate system of how our court system works, and which is simply to say that the decisions of higher courts are not singular. So the first instance judge who dealt with that matter of injunction, amongst other things, it went to the Court of Appeal. You have a Court of Appeal of 3 judges, And then you went yet higher.
Again, remember, move on from that particular aspect of it. Right?
Yes,
if I
please.
didn't make myself clear just now, right? But the whole rationale behind the Privy Council ruling and the this one and that one and the numbers, move on from that particular point.
So, Mr.
Every
Deputy
member
Speaker,
spoke about that.
Yes, Mr. Deputy Speaker, I'm not on the numbers. I'm on when you go higher in the appellate system,
Member,
you have more judges.
Member, I have so
Yes.
ruled.
Yes.
I have so ruled.
So, Mr. Deputy Speaker, let me make this point very clear without numbers. You have collective wisdom of the appellate courts, and that is what we abide by. So, I move on from the virtues of collective wisdom, and I go to another point which was raised by member for Port of Spain South. Now, he spoke a lot about democracy and what prevails in a democratic society. And when he was speaking, I thought to myself that if we are talking about democracy, how is it in a democratic society we would take decisions to postpone people's electoral rights with vague legislation? Why would you do something like that? Member for Siparia, leader of the opposition, questioned why would you want to postpone the general elections? I go no more into that. But if you are talking about democratic rights, you have to look at what is the will of the people. You have to act in the interest of the people. You rule by the people. And you do what is in the best interest for them. You rule for the people. So I don't know what argument he was attempting to make when he said that in a democracy, PNM stands for democracy. I think the PC ruling says otherwise. So I would advise him to look at that again. And I believe he may have quoted a speech of the late Dr. Eric Williams. And I want to let him know that in that same speech, Dr. Eric Williams was the one who said, democracy is much more than the right to vote. But in doing so, he took it as a given that what was the main right of a person would not have to come to court and fight for that right, Mr. Deputy Speaker. So he took it as a given that that was a right that everybody would enjoy. Never in his comprehension he would have thought that you would have had later incarnations taking away that right. Now, Mr. Deputy Speaker, just one of the points which I heard a previous speaker talking about, and I would just like to respond to that. This is particularly member for San Fernando West. And he made this broad brush statement about how member for Siparia was somehow or the other acquiescing or maybe encouraging acts of fraud on the part of councillors. Now, this is something that I want to say. I want to remind member for San Fernando West of an investigative journalist piece which was reported in the Trinidad Guardian on the 16th of July 2019, one by Mr. Mark Bassant. And what that Guardian article is entitled, Gangsters Benefit from Contracts Through Corporations. And what it says in this article was that money was paid to alleged gang leaders, Mr. Deputy Speaker, based in communities in the Port of Spain to Digger Martin areas over the last 3 years. That is a 2019 report. And it went on into how several reputed gang leaders in North Trinidad have benefited from state contracts worth close to $6 million.
48-1, please. Oh, please.
Again.
It's not relevant.
Okay, members, listen, I need to rule, okay? I need to rule. I need no help from on both sides. Okay, again, so now remember you said you were responding. So again, I would like you to tie it up and bring the rationale within the particular bill.
Yes.
Right?
Thank you, Mr. Deputy Speaker.
That's to wrap it up.
Yes, thank you. I will wrap it up quickly. So what the investigative journalist piece said was that you had reputed gang leaders benefiting from state contracts to some total of $6 million in spite of the fact that you are dealing with crime, increasing crime, and it spoke about the government's role in this. So when it is member for San Fernando West takes a position that on this side we are somehow acquiescing in fraudulent conduct. Far from, Mr. Deputy Speaker. Our record on this side will show that once there is proper evidence brought forward, that evidence must be channeled to the appropriate authorities, and the appropriate authorities must act. That has always been the track record on this side. So, Mr. Deputy Speaker, I want to dismiss. I know you have given me some limited room, and I abide by that. But to say that that article is something gangsters benefit from contracts through corporations, it wasn't any UNC councillor or UNC corporation. So I put that on the record. Now, Mr. Deputy Speaker, I want to say that in terms of the, I know I have other colleagues who will come after me, but I want to place it on the record that if we are talking about validation legislation, I want to put it on the record that an amendment, a proposed amendment signed by member for Barataria Sawan, and it ought to be in circulation already. We are making a proposed amendment to this validation legislation, and that is following the advice from member for Siparia, Honorable Leader of the Opposition, that Clause 5 should be deleted outright. And I want to say that when I heard the Honorable Attorney General and I heard member for San Fernando West, they provided no clarity, no incentive as to why it is that Clause 5 in the bill would somehow provide assurances in the interest of the public. And let me explain that. From the very inception, when we had the judgment of the Privy Council, the Honorable Attorney General spoke about the fact that we ought not to be concerned. And we ought not to be concerned because he had reference to some venerable and old aged principles of law, namely de facto officers and de facto conduct, which is in contrast to de jure. But he spoke about de facto principles, and that de facto office principle is one which he said would cover all actions of councillors and local government officials in question until the ruling of the Privy Council, which was the 18th of May. These were the words of the Attorney General. I believe he would have cited cases like Scaddle and Laurent and some other authorities, very, very old authorities. But they remain good law. So if we are to take the Attorney General by his own analysis, and we presume he's acting on advice as well, that if it is you have all the local government officials being protected and any transactions conducted on their part, albeit without the color of lawful authority, that the de facto principle will apply to them and protect them until the 18th of May, one questions why this bill is being brought, this Clause 5. And even if you want to make it certain, let's assume you want to make it certain that you now have the weight of statute, the weight of legislation to protect these officials, then why is it that you are going beyond the 18th of May? And not only that, it is not just going beyond the period 18th of May till now. It is going until sometime in August, 18th of August. Mr. Deputy Speaker, this is not the first time that we have had to hold a local government elections in Trinidad and Tobago. So you would normally have a situation where certain persons would continue in office, and if they act outside of authority, they can be held liable. If they acted even outside of lawful authority, but they acted with bona fide intent, there are principles such as the de facto that will apply to them and protect them. But in this case, why, and to echo the sentiments of Leader of the Opposition, why are you going further than today? Why are you going to such distant time in the future, 18th of August, to protect all the actions of these persons? What is it that they intend to do so? If it is we now accept, based on the Privy Council ruling, that the local government election should have been called in March 2023, and now we have a mandate from them as to how we can act lawfully. Why are we including this Clause 5? So it is somewhat absurd as a matter of law and also as a matter of fact to bring that Clause 5 to say that we want to cover the actions of all officials between November 2022 to August 18th. And this brings me to the other point, Mr. Deputy Speaker. Why not just cure all of this and simply announce the date for local government elections? Why is the government running from calling this date and holding the elections? I could say for sure, with certainty, we on this side, we are ready for the local government elections. I could say with certainty, my sister from Chaguanas East, we are ready in Chaguanas, we are raring and ready to go. And I see another colleague of mine on the other side. I hope he doesn't feel he can infiltrate Chaguanas. So, yes, so Mr. Deputy Speaker, the point is, the point I want to make is that why are we legislating for something which is already provided for in the law, and we can just simply trigger by the local government elections by announcing the date? Why are we doing this? So I leave that there, Mr. Deputy Speaker. Now, another point I want to make is that I can understand with respect to the clause 5, and I don't think this was mentioned, and if it was mentioned, I highly doubt it was by the Honorable Attorney General. And you see, the point that has to be made so that persons on the outside can understand why this clause 5 is coming, certainly in part, is because while the de facto doctrine will offer protection and give lawful authority to the officials, it does not validate invalid legislation. So that is a point which we cannot hammer home enough. It is a situation of where bad law has been brought. It is a situation of where we had to get the Privy Council to rule. And now that we have the benefit of that ruling, what it means now is that we are now passing a law to validate invalid law. And this really is an undesirable state of affairs, Mr. Deputy Speaker. So, the last point which I wish to make, Mr. Deputy Speaker, is we have in Trinidad and Tobago a system by which local government operates, the Municipal Corporations Act. I have already said, Mr. Deputy Speaker, that we know what the pertinent provisions are for the purposes of today's debate. We have maintained that we are not in support of Clause 5, and we have proposed that amendment, which is a total deletion of Clause 5 of this bill. We have also put on the record that our position is that the date for local government election should be announced forthwith, and that is not today's position. We have been saying that since November 2022. We have been saying it in May 2023. And here it is again. We are here today to say announce the date. But what is important about that? Mr. Deputy Speaker, under our Constitution, and I have referred to it, but I will not repeat what I've said before, this rule of law, which pervades the very fabric of our laws, which pervades our society, which is the backbone of our democracy, that rule of law, which some people think is the domain of lawyers, but really and truly, it is the pillow that every citizen, law-abiding citizen, sleeps upon every night. This rule of law is something that we are being judged by. All countries in the world, some 140 countries are being judged by this rule of law. A government and a society's adherence to the rule of law is something that is now being measured. There's a tangible measurement that is apportioned, and we are being measured. Why is that important to this debate, and why is it important generally? It is important to this debate because the actions that we have seen since November 2022 till now will make us drop in the rankings in that rule of law index. That is what is pertinent here. And that is not a good sight. That is not a good evaluation for Trinidad and Tobago. And outside of this debate, I say outside loosely, what is the importance of that ranking? It is because our international counterparts, business counterparts, foreign investors, everybody is looking towards that to determine whether Trinidad and Tobago is a place where they want to come to invest, or they want to spend holidays, or what have you. And we have dropped in that rule of law index, Mr. Deputy Speaker. Between the pandemic 2020 to 2022, we dropped one place. 63 out of 139 countries is what we ranked. And we have now had the 2022 till now, that index.
Okay, Honorable Member, your initial speaking time has elapsed. You have an additional 15 minutes. But before I present for you to accept, I would like to suspend the sitting at this time.
Yes, please.
And we'll resume in 30 minutes. We'll resume in 30 minutes.